Any mention?
Please, Lordship. Lordship, I beg to mention item number 51, 51, 52, 53 and 54 connected matter, my lord.
Which is PDF matters?
Yeah, Lordship.
Why?
Lordship, Mr. S.K. Hassan is on leave.
Mr. S is in bereavement.
Yeah.
Number 51 to?
51 to 54.
51 to 55, sir.
Item number 49 and 50 also connected with the
Okay, item 49 to 51. So to 55.
54, 54.
To 54. Is submitted due to the bereavement of Mr. S.K. Hassan, having counsel in these connected matters. When?
Lordship, after vacation.
After vacation? This is matter first week of June.
Lordship.
Yes.
Obliged, Lordship. Obliged.
Lordship, I beg to make a mention of item number 41 of the main list, Lordship. 41, Lordship. 41, Lordship. This matter, Lordship, what has happened on the last occasion, the respondent, newly impleted respondent number, they have filed their report, Lordship. So now, Lordship, however, Lordship, senior Miss Apol is leading in this matter, Lordship. She is out of station, Lordship. I am praying.
Which 41?
41, Lordship. Balbinder Singh, Lordship. Contonement matter, Lordship.
I don't know who's leading the matter, but K-Paul is there.
Lordship, Miss Apol, senior counsel, is leading, Lordship. She is out of station, Lordship. So, I'm praying for 2 weeks, Lordship.
Take 3 weeks.
2 weeks, Lordship.
4 weeks, fine.
2 weeks, Lordship.
3 weeks, yes. On the request of Mr. S. Chandar.
Well, maybe after 3rd, 4th, 5th, I think I'll be out.
Yes, list on
3rd, 4th, 5th.
List on 2nd week of June.
Much closer.
It please your lordship, I beg to mention items number 42, 43 and 44. They're all connected matters, lordship.
Where's Mr. Upadhyay? What's the matter? Disability pension?
Lordship, disability pension, lordship. Lordship was supposed to take instructions on some documents that has been provided by the petitioner. Yes. We've not received the same, lordship. I'm praying for some time.
Any objection?
No objection, lordship.
Yes, on the prayer of, on the request of so-and-so, to allow her further time to obtain instructions. The matter stands adjourned for 2 weeks. Yes.
Lordship. Highly lordship.
Yes. 42, 43, 44.
Lordship.
Okay.
May I please see your lordship? Your lordship, I beg to mention item 55, lordship. I've taken the concern of the petitioner.
Item?
55, your lordship.
No objection, your lordship.
Why this matter you don't want to do? 2 weeks, yes.
Obliged, your lordship.
Your lordship, I beg to mention item number 40. Lordship, have it after 2 weeks.
What's the matter about?
It's appointment in sericulture, Department of Sericulture.
He's serving or aspiring?
He's
serving.
Your Lordship, I'm not the counsel in this matter. Your Lordship, however, we've been told that we require some instructions from the department as well.
Okay, after 2 weeks, yes.
Obliged, Your Lordship.
Please, your lordship. Lordship, I beg to make a mention of item number 56. The matter is still pending in the Supreme Court, lordship. Similar matter.
Okay. MS K.D. Cruz. You are the LAC, Legal Aid Council. Submit as the similar matters pending conclusion before the Supreme Court. And this the same be listed after?
My lords, after 3
6
weeks.
weeks.
Lordships.
Yes, 6 weeks, yes.
Highly obliged, lordships.
Prayers are all listed for 6 weeks, yes.
Supplementary list item number 1.
Service, my lord, under Rule 26. Our contention is that, my lord, Rule 26 was not followed and he was not given the opportunity to be referred to a civil hospital and file an appeal, my lord. But then since he is already discharged, my lord, I am praying for notice only at this stage, my lord.
When was he discharged? 25.
25.
Mr. Pathak, learned counsel for the petition issue notice. Dr. M. DSGI with so-and-so is present. No further notice required on the respondents. This after 3 weeks for instruction.
Obliged.
2. Item number 2.
May it please Lordship. Lordship, here the petitioner husband was a retired chainman, Lordship, working under the office of the Deputy Commissioner, West Garo Hills. So he was, after his retirement, he was receiving pension. Then he died on 13/2/2024 at his daughter's place in Assam, Lordship. Now, Lordship, this death certificate was collected by the daughter, as was informed by the hospital authorities. Then the petitioner.
Where did he die?
He died on 13/2/2024
Where?
at Assam, Lordship, under Walpara district, Lordship. Then he approached to the hospital authorities. They are orally saying that the certificate has been collected by the daughter's, Lordship.
My
Then-
daughter is not staying with you.
No, daughters from the first wife, Lordship. And the first wife is,
that issue.
the first wife is no
Who is the
longer,
first wife?
I am the second wife, Lordship, but the first
Legally
wife
married.
died.
Legally married.
Yes, Lordship.
Marriage certificate is there.
Marriage certificate as well as the nomination also, Lordship will see my nomination. Marriage certificate is at page 9, Lordship.
But their judgments duplicate can be issued to you.
That is why, my lord. So when I send a legal notice, that kindly give me a duplicate copy of the death certificate. Now they are saying that we did not issue any death certificate in the name of so and so.
The name of whom? Of the deceased person?
This is, yes, Lordship. So my lord, my nomination will find at page, Lordship, page 12, Lordship. Below is the family details,
What's the
Lordship.
name?
Name below by Tez Bina Momin,
Name of spouse. Okay.
spouse, Lordship. Then I have 2 children. Now my lord
Seeking
will,
notice for Richard
if the
represented by whom? Number 6 is represented by whom? Registrar. Who the registrar?
register, Lordship, register of birth and death.
There's a specific registrar birth death in the PHC itself.
No, it should
He
be
who's given that position.
the
Registrar of birth that's a different office.
in the PHC also they have that register of birth and death, Lordship.
Okay, heard Mr.
Or if the birth certificate is collected by the respondent number 6, 5, they can.
Issue notice. Mr. E.R. Khan is present accepted on behalf of respondent 1, 2 and 3. 1, 2 and 3. Mr. K. Kamar Plan is present on behalf of number 4. No further notice to this respondents. Petitioner takes steps for service notice respondent 5 and 6 within 3 days. Yes, just after 2 weeks. Yes.
Hello.
Daily 1.
Please, Lordship. This matter, Lordship, pertains to the non-disposal of that representation actor. May be allowed to withdraw, Lordship, with the liberty to approach.
How can you come to the High Court directly?
Lordship, we had sent a copy, Lordship, to the, but no reply.
Yes?
We had sent a copy to the Department of
Doesn't
Education.
matter. Copy what is against the governing body. You can't come to the High Court. Say, yes,
Lordship.
Mr. Arkrakang submits instructions or submits that he may be allowed to withdraw. No, please be allowed to withdraw that application. Yes.
Lordship, with liberty to approach the
Liberty to approach the
Department of
Education. Yes. Please allowed. Matter stands for withdrawal. With liberty as played this.
2.
oblige.
So for a petitioner.
Item number 2.
Outstanding counsel.
Yes, Pandey. Where's S. Pandey? Mr. Pandey. Yes.
I'm only the local counsel, Lordship. I think somebody was supposed to appear from VC, Lordship. Lordship, this matter pertains to issue of domicile certificate, Lordship. The petitioner is a native of Gujarat, Lordship, and he enrolled into Assam Rifles based on the strength of domicile certificate issued from Executive Magistrate Himmat Nagar, Gujarat. Lordship, he was served the show cause notice, Lordship, dated 26th March 2024, wherein it has been stated that it is at page number 26, Lordship.
Fake domicile certificate.
Lordship, that's the issue, Lordship. That so-called notice has been issued to him, and he has filed a reply, Lordship.
Mr. S. Pandey.
Notice in there.
That Contempt issue notice Dr. N. Musica with MS Sijala is present on behalf of the respondents. No further is required. Just after 3 weeks for instruction of affidavit.
Much obliged, Lordship.
Item number 3.
Yes. Yes, Mr. Jindal.
My lord, Lordship, on the last occasion, unfortunately, I could not be present personally, because of which it appears there was some communication gap between me and my colleague. This impleadment intervention petition which has been filed, we have no objection as such against it. Instead of an objection, my lord, what we have, my lord, is a request. A request for this honorable court to kindly examine at the time of adjudicating that petition whether the scope of that petition aligns with the scope.
Extend, yes.
Aligns with the scope of our.
That is the only question, because your writ petition, the prayer three different impleadment, they can cover us with another.
Because
different cause action altogether.
The right to file a. The right to file an independent writ petition is always available, and as it is, my lord, has noticed, there are others also already.
One second, Mr. Sankara.
So,
yeah, Mr.
Vishnu Shankar Jain.
Yes, Mr. Jain.
Mr. Vishnu Shankar.
So we have no objections, but a request just to examine the scope. That's all.
Yes.
Yes. May I respectfully submit? Yes. Yes. May I respectfully submit the intention of the impleadment applicants is not at all to enlarge the scope of the present petition. We are within the scope of the present petition. We are asking our fundamental rights to worship there, which completely aligns with the scope of the present petition. That is point number 1. And Lordship may kindly appreciate, I wanted to point out before this honorable court, the order passed by the honorable apex court. We had went to the honorable apex court. The apex court directed us to participate in the present proceedings. That order is annexed in my application, which is application 115, page number, yeah. My lord, I'm just saying.
Yes.
The page is page number 11.
Yes. Number 10, page number 10.
Lordship. I'm so sorry. Lordship, yes. May I just read it for a moment?
Yes, yes.
Mr. Shyam Diwan, landed senior counsel appearing for the applicants, petitioners, state that this application seeking permission to file SLP may be dismissed as withdrawn, leaving it open for the applicant petitioners to participate in the proceedings before the single judge, before the learned single judge. We order accordingly. So, my lords, we have taken liberty from the honorable to participate in the present proceedings, and we are completely aligning with the scope of the writ petitioners, and we are also seeking our right to worship at the premises in question. So, my lords, I don't think that there is any difficulty and there is any concern for us to file a fresh writ petition. So
yes, what objection does the yes, not what objection
has been filed by the objection has been filed by respondent number 9.
Yes.
Of the writ petition.
Yes, what's the objection?
My objection, my lord, due to the claim in the listener's application that in the para number 6 that land is belong to the common land. This land is not belong to the common, it's belong to the Sangasi organization. That's handed over by the scheme of Imam Musantam, and already has been registered date but register number 625 2015.
The thing is that your objection only to that.
Yeah, to that.
Yes.
Because we are welcome.
See, Mr. G, and objecting to any will take that in consideration. Yes, what's your prayer? Here for a number? Number?
6, 7, and 8.
6, 7, and 8. Yes, we will do one thing. We'll allow them to intervene. Let them bury this party. And you file, or we file your affidavit. Yes. Miss Case 115/2026. So and so. This application is for this application for intervention to impede the applicants as party in the proceedings. Stop, Mr. Shankar Jain, Leonard Counsel for the applicant petitioner, submitted
Vishnu Shankar Jain.
Oh, sorry, Vishnu Shankar Jain. So and so. I submitted that the application has been filed pursuant to an order of Supreme Court passed in SLP so and so, is that right? in the case of so and so, whereby the Honorable Court has allowed the applicants to participate in the proceedings before this court. Stop. Objections have also, however, been filed by the PIL petitioner, who's arrayed as respondent number 9, with the question of the title to the land. Stop. Your MS dealing the learned counsel for 6, 7, and 8 has also submitted that no copy of the missed case has been served on them. On consideration of the matter, notwithstanding this fact, and with order of the Supreme Court, the applicant is hereby arrayed as party respondent in the instant proceedings and permitted to file a detailed affidavit stating their contention. Stop. The parties thereafter are permitted to file their objections or replies to the same. Yes. Registry to make the necessary correction in the array of parties in the court title. This case allowed and disposed of. Yes.
I'm so grateful.
Yes.
Item 04.
Yes, who shall argue? Where is he? We have to join him or he has to join us?
He's online.
We'll take it. How long you will take? An hour? We'll take it end of the board.
5.
Please,
What is this?
Lordship, on the last occasion, your Lordship had asked me whether to come in instructions whether I want to pay the compensation or not, your Lordship.
Pay the
compensation, my lord.
Compensation.
Environment compensation.
Yes, you know, pay the compensation.
If your Lordship can kindly have the additional affidavit filed by the board, your Lordship.
By the board, in the missed case?
17 of 2026, my lord.
In the missed case?
Yes, my lord.
The affidavit in the missed case? Yes, okay.
Your Lordship can
additional affidavit?
Yes, your Lordship.
Filed by you?
No,
By me, my lord. 17 of 2026.
Objection?
No, it's not an objection, my lord. It is to show. It is to show here, my lord, that they have approached us.
152 pages of the affidavit.
That is filed by me, your Lordship.
Then where's the reply?
You have not replied.
No, what is? You're talking to Miss Case 17, correct? Then what additional have you seen? Please be clear.
This is objection.
My lord, in the meantime, if I may please point out that I had filed an application for impleadment, and after hearing the petitioner and the main respondent, my lord may kindly hear me also.
Yes. This matter is passed in, yes. Where's your, what Miss Case is your applicant impleadment?
It's this one.
Miss Case number?
That I will request Mr. S. Thapa there to assist this on court.
It's this
one. Number 17.
It's this one.
Total confusion, yes. Where's the additional affidavit talking about?
It's this one. It's the 17 one.
Yeah, Miss Case is 17.
It's a 17. 17 and 2026.
Miss Case 17 for impleadment. What additional affidavit Miss Case 17?
17 is for impleadment.
Yes. Now, Mr. Pasante, what do you want?
The additional affidavit filed by the board.
Where?
It was filed on the 9th of June, your Lordship.
At least assist the court, you.
Which one are you talking about?
Come on. Huh? It's filed the main case. What do you see in this case? The order was passed in this case whether you're going to pay.
Yes,
Yes. Are you going to want to pay compensation or not?
Your Lordship, we have submitted a proposal, Your Lordship, for waiver of the
Page 11, my lord.
page 11, Your
Of the additional affidavit.
Yes, Your Lordship.
Okay.
We have submitted a representation for
Then
grant
just
of-
also murmur record kane. Murmur record kane. 96 murmur record. Have it tomorrow. Lot of confusion. Even in the noting.
on Friday, Your Lordship.
96. Okay,
My lord,
Friday.
my lord, Friday I am not here, my lord.
Then someone else will be there. Yes.
My lord, there's nobody from the pollution board.
See who filed this additional affidavit?
I did, my lord.
You filed additional affidavit.
Yes, my lord.
You just see what
I'll do that. I'll do that, my lord.
you see
I'll
what
check.
you see what we've written here. You're ahead of your time, miss.
Can I see?
This 9625 or 26.
26, my lord.
Then now you're ahead of your time. See,
No, there's another one, my lord.
this is filed when?
It's filed on March, Your Lordship. March of 2026.
March 2026, my
This is
lord.
9626 or 96. I saw 9626 also.
Yes, there's
What is
another
25
one.
then?
My lord, 25 was the first one. We filed the latest one. The
Then
latest is
yes,
26.
Parties are directed to what order should we pass? We don't even know. We don't even know what papers you're placing.
We fixed for the date, my lord. I'll check the case records.
I thought
I'll
it's
put it on record.
96 now.
I'll check everything, my lord.
25.
The latest is 26, March 26.
Parties to examine the records. Yes, to assist the court in a proper fashion. Yes, list on Friday.
Item number 6.
Otherwise,
A week's time, my lord.
Very grateful, ma'am.
where Dr. Mozika?
He's on Lex Lordship. I'm
Where?
paying.
You brought authorities?
Yes, my lord.
Let us see.
My lord. Judgments, my lord. Yes, my lord.
Where that clause 70
Yes, my lord.
will
Yes,
not, only the retiring will go and the other requirements will remain.
Yes, my lord. I just placed 4 of the judgments, my lord.
Yes.
Well, my lord, the larger issue has been discussed, my lord. What has happened, my lord? Once the appointment, my lord, I'll just show, my lord.
Yes.
Before going to the judgment, my lord, I would just want to place section 11(8), my lord, first, my lord. My lord, what it says, my lord. If you go by
cuts against the very grain of the act.
Yes. No, my lord, what has happened, my lord? My lord, 11(8) says, my lord, the institution before appointing an arbitrator shall seek disclosure in writing from the prospective arbitrator.
That is see.
Yes, once the appointment
Once
is
the High Court has appointed arbitrator, rightly or wrongly, does have jurisdiction to, you go and appeal.
No, my lord. Now, in this regard, my lord, what I am submitting, my lord, once, my lord, the consent being given, my lord, this is not automatic appointment, my lord, because, my lord, section.
You're going to go there.
Yeah, my lord.
Court becomes functus officio after 11(6). Yes.
This has been discussed, my lord. But my lord may kindly see that 11(8) before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator. This is the status, my lord. The provision says, my lord, before appointing an arbitrator.
That's already been received.
My lord.
That's already been received on record.
My lord, but disclosure has not been given, my lord, as of yet, my lord. My lord, I will just show, my lord, 2 of the judgment, my lord.
May it please your lordship, if I may interject.
Yes.
Lordship, if this matter may come up at the end of the board, lord.
Let them argue, doesn't matter.
Yes. My lord, the provision itself indicate, my lord, 2 things is very much required before appointing an arbitrator, my lord. So, my lord, I will just go through. If lordship says, my lord, that 11(8), my lord, this is very crucial, my lord, because these judgments are, my lord, only after appointment, my lord, review is not maintainable. But, my lord, in certain cases, review is maintainable, like our cases, my lord, because the judgment where, my lord, this review has been discussed in there, my lord, whether this review has a jurisdiction of the High Court to do it or not, my lord. So, I have just placing, my lord, this judgment, my lord, just to show, my lord, that, my lord, lordship may kindly come to the last para, my lord, of this judgment, my lord.
Yes.
Accordingly, so-and-so, district so-and-so is appointed as an arbitrator to arbitrate and decide the disputes between the parties. In connection with agreement number so-and-so, the written declaration is kept as a part of the case record. A copy of the... So what I'm submitting,
so what does it mean?
It mean, my lord, the written disclosure under section 12 has to be given first. Thereafter, my lord, on acceptance of it, then only that arbitrator can be appointed, my lord. That is the statute says, my lord. If I read the statute once, my lord, let me kindly. The arbitral institutions referred to in subsection 4, 5 and 6. Before appointing an arbitrator.
Where are you reading?
Yes, 11.8, my lord.
Yes. Yes.
The arbitral institutions referred to 4, 5 and 6. Before appointing an arbitrator shall seek a disclosure in writing from the prospective arbitrator.
Yeah.
So as soon as the consent being given, he is still a, my lord, a prospective arbitrator, my lord. In terms of subsection 12.1 and have due regard to, my lord, one, any qualification required for the arbitrator by the agreement of the parties, and secondly, this court has to see the content of the disclosure and other considerations as are likely to secure the appointment of an independent and impartial arbitrator, my lord. So, my lord, this disclosure has to be submitted.
Where are you seeing the court has to see where written that?
The content of the disclosure.
Read again. The arbitral institution referred to so and so before shall seek disclosure in writing her prospective arbitrator.
Yes.
So and so,
before appointing.
And have due regard to.
Before appointing, my lord. Before appointing, and have due regard to the any qualification required and the disclosure, my lord. In our case, my lord, I specifically mentioned in para 10 of my petition, my lord, the educational qualification is engineering degree, my lord, and that part has been overlooked, my lord, by both the parties, my lord.
We're not concerned with that. We're concerned with whether we can review one order.
Yes, that part, lordship may kindly see, my lord, the judgment that Hindustan, my lord, 2026 3 SSC 264, my lord.
Yes.
And now I will take your lordship.
Para
40, my lord. In this case, my lord, what has happened, my lord? Already the arbitrator was appointed, my lord. The proceeding has gone, my lord, for about 3 years, my lord. And my lord, then extension of mandate of the arbitrator has also been filed, my lord. Thereafter, my lord, petition has been filed the review of the appointment of the arbitrator, my lord. Then that issue
circumstances, because it's gone for 3 years, it couldn't
yes, my lord. Yes, that is what, my lord, I am saying, my lord. This review is not at all maintainable in that regard, my lord. So while framing this issue, my lord, the discussions are just pointing out, my lord. Yes, my lord. Lordship may kindly come to, my lord, page 40, my lord. Yes, para 40, my lord.
Yes.
40, 41, 42, my lord. Although the power exercised by the High Court under section 11 is judicial in nature post SB P and company cases, its scope remains narrow.
Yes.
Once an arbitrator is appointed, the arbitral process must processed unhindered. There is no statutory provision of review or appeal from an order under section 11 which reflects a conscious legislative choice. While the High Court as a court of record do possess a limited power of review, such power is extremely circumscribed in matter governed by Arbitration Act. It may be exercised only to correct an error apparent on the face of the record or to address a material fact which are overlooked. It cannot be used to revisit finding of law or reappreciate issue already decided. In Greenleaf Bank Limited versus Central Government Industrial Tribunal, this court drew a clear distinctions between procedural review and review on merit, holding that latter is impermissible. That means review on merit is impermissible.
Okay, now come the second part now. Now that clause 70, that part regarding retired is gone.
My lord.
Serving, sorry, is gone.
Yes.
So doesn't the whole clause go?
No, my lord. My lord, that in that regard, my lord, I will just take a lordship to 19.7 of that judgment, my lord.
Same judgment?
Yes, same judgment, my lord.
You give a copy to them?
My lord. I have not. I'll just carry it.
Yeah, you should at least give a citation.
Yes, my lord. 19.7, my lord.
Yes.
It is further contended that two parts of clause 25, like our, my lord, in our case, my lord, serving officer, my lord, one part and second part is qualification of the, my lord, of the arbitrator, my lord. It was further contended that two parts of clause 25 are separable. The first part now unenforceable due to ruling of court. There is my lord, there is a central organization for railway electrification case, my lord. That is my lord 2025 2 SSC, my lord. Can be severed without affecting the remainder of the clause.
What is the clause that was severed?
Yes, my lord.
What is the clause here that was severed? Same.
My lord, not same, my lord, different, my lord. Different, my lord. Here it says, my lord, two part, my lord. This first part says, my lord, that that matter has to be decided by an arbitrator, and second part is that, my lord, who will be the arbitrator, my lord?
See, the thing that arbitrator, in this case, it's serving officer who has a degree in engineering, correct? But now that clause is gone.
My lord, my second submission.
Sorry, serving officer, correct?
Yes.
Now that part is gone.
Yes, my lord.
So serving officer is gone. So one serving officer having a degree in engineering, the whole clause go.
My lord, my respectful submission is that, my lord, if it is separable, my lord, because, my lord, the whole intention of the, my lord, this clause, my lord, was that, my lord, this is a technical work, technical persons has to be decided, my lord. That is the whole intention of this.
So we modify the order accordingly. Let the arbitrator take assistance of an engineer.
My lord, what I'm saying, if the qualification is of an arbitrator is to be engineering degree, my lord, his appointment will be.
You have not satisfied the court on that point. There is severability of that clause. It's serving officer who has engineering degree. Now that clause is gone.
No, my lord, the serving
now how can you say that only retired officer goes and having engineering degree?
My lord, if I continue this, my lord, once, my lord, because what I'm saying, my lord, exactly the term is that, my lord, serving officer having an engineering degree, my lord. So it is two part, my lord. My respectful submission is that the serving officer is one part and second part is the qualification, my lord. And lordship says, my lord, even, my lord, in many of the cases, my lord, the engineers have been appointed, my lord, in that regard, my lord. So I will just read, my lord. Doctrine of severity has been discussed, my lord. The second part, which is independently records the negative covenants against the arbitration, remains valid and binding. The doctrine of severity and the blue pencil test, as recognized by so-and-so case and so-and-so case, allows offending portion to be struck off while giving effect to the surviving portion that reflects the party's intention.
Yes.
Upon such severance, the second part of clause 25 stand independently and unambiguously express that dispute should not be referred to the arbitrator. The 19.8 is, I just read one line, my lord. It was submitted that it is a settled position principle that courts cannot rewrite or modify the terms of the contract, my lord. So, my lord, my respectful submission is that, my lord, condition 70 indicates, my lord, serving officer one part and qualification other part, my lord. In para 10 of the petitions, I have specifically mentioned, my lord, that, my lord, the qualifications of an arbitrator should be, my lord, should have an engineering degree, my lord. And, my lord,
you give the copies of the judgment.
Yes, my lord. I'll judge
sometime.
Yes, my lord.
You've heard the arguments.
Yes. 7.
Yes.
Still pending.
Yes, sir. 1 and 2.
Matter is still pending, your lordship.
This matter is pending in the.
It's regarding boundary dispute.
No, your lordship, that airport compensation, your lordship.
The matter, I came before your lordship, and another party has gone to the Supreme Court. So the
same similarly situated.
Lordship, against the order, against this
in
order.
the same order. So the matter is still.
You went.
Order number 4.
So, your lordship has been so long awaiting the outcome of the Supreme Court order. So, it may be awaited for some time more.
Yes, it's reported that the connected matter is still pending constitution for the normal Supreme Court. This is matter of 6 weeks. Await any outcome. Any idea what's happened to the matter?
It has not been listed.
Admitted for hearing. Then it'll take 5 years. Yes.
No, it has not been admitted for hearing. It is fixed for filing replies and all that.
8.
Obliged.
Yes.
Obliged.
My lord, we could not settle this matter, so allow me 1 week's time, my lord, to file a counter affidavit.
What's the matter about?
Service matter,
Pension,
my
my
lord.
lord. Pension matter, my lord. For
Why?
authorization.
You could not settle your which department?
Yes.
MECL?
No, my lord.
PH department.
You're entitled to compensation?
1 to 7, my
Yes,
lord.
my lord.
You have instructions with you?
Yes, I do, my lord. I have received
Yes.
instructions.
What is? When did you retire?
28 2025. 28th February 2025. No. Annexure 6, my lord. Page 25.
What are the hindrance?
My lord, decisions were made. His name was already recommended, my lord, to be regularized. But the thing is, my lord, the cabinet decision has to take place, my lord.
What cabinet decision? When his name was sent by DSC, correct?
Yes, my lord.
Then?
The cabinet has to take these decisions, my lord. We're waiting for those decisions, my lord.
It was sent
I will
pursuant to
show you
22.
Yes, my lord.
DSC.
Yes, my lord.
Otherwise,
Here, my lord.
you file after you get it. You file it within
In a week's time.
In 1 week. Yes.
Yes,
The matter is returned from mediation proceedings on being unsuccessful. Stop. MSOAI Bank line. Place on the 1 week's time to file. Just thereafter. Right.
Wait, please, Your Lordship. We've given them an advance copy, Lordship. We'll be filing it in due course of the day.
We have received the copy.
You file rejoinder?
Right.
Yes, MS Emerchang. It's already on record as our channel council pays for allowed 2 weeks time to file rejoinder. We'll have to file by the respondents. It's about 2 weeks. Yes.
I'll oblige.
10.
Your Lordship, on the last occasion, my Lord allowed to seek instruction from the petitioner. However, we couldn't get in touch with the petitioner because petitioner is suffering from some mental disturbance. So kindly give us one last opportunity, 2 weeks time to seek instruction.
What facts emerge from the affidavit?
Lordship, the petitioner here is claiming for his pensionary benefit. But then, as per our affidavit, Your Lordship, he was absent, unauthorized absent for 235 days, Your Lordship. So in this regard, the petitioner is supposed to take instruction.
He's got mental health issues.
So, mental disturbance.
Yes, confirm petitioner. Please hold out further 2 weeks time to obtain instructions. Yes.
Much obliged.
11.
Pursuant to the directions contained in order dated 9/4/26. Yes.
Affidavit has been filed by the respondent number 4, Lordship.
Yes.
So 1 week time may be allowed to the petitioner to go to. Other respondents are not contesting.
You. Yes, against AG in this case.
Yes, Your Lordship. But then I think this matter can be disposed of, Your Lordship, with the direction. Because see, what has happened is they entered into compromise. Now the respondent number 6 also have way of her right. So if this matter can be disposed of and direction may be given, and the petitioner
AG wants only a direction. So.
Where you said in your affidavit that you have no objection if
Lordship, nothing like that, but then I've got a specific instruction, Lordship. Because there's a low court's order also is there, Lordship, but then this page number 54, Lordship, of my affidavit.
Yes.
The last one. So this letter has been issued to the petitioner. Lordship, this letter says like this: in inviting to the reference
to the petitioner. Yes.
Yeah, in inviting to the reference letter number so and so dated so and so, I am to state that in absence of any specific judgment from the court of law, this office is not in the position to issue fresh PPO based on the strength of the deed of compromise between the parties submitted from your end. And in the absence of a judgment order, you are requested to take up the matter with the finance department, which is the competent authority to relax and interpret the MCS pension rules 1983 through the concerned head of the office for necessary action at their end.
Where's your deed of compromise?
Deed of compromise
It's,
is
page 49 of my affidavit, Your Lordship.
in writ petition it is page 81.
81.
81. 82 onward it starts.
Yes, take down.
This compromise was accepted by the
both parties.
Yes, Lordship. And the order was also there. It is page 89. And page 90 is relevant.
You waive all your rights.
Yes.
Yes, take down. The petitioner, who stated the second wife of one late Resman Lapang, RESMN Lapang, he died in harness on 9/5/2029 while serving in the police department, is before this court praying for directions. For issuance of the pension payment order in her favor, and also for other term benefits as payable. Stop. Next paragraph. Mr. Upadhyay, Learned Counsel submitted that the petitioner that the deceased employee had a first wife who has been arrayed as respondent number 6, represented by Mr. B. Kriam, and who had filed an application for grant of succession certificate before the district council courts. Stop. The matters he submitted had culminated in the judgment dated 4/4/23. Where is it?
Would be 23, Lordship.
Had culminated in 4/5/2023. Whereafter the petitioner approached authorities to give 50% of the family pension other dues. What whereafter culminated in the judgment decision whereby the respondent number 6 was allowed the said benefits and family pension. Thereafter, the petitioner approached the authorities for grant of 50% of the family pension other dues, and later came to learn that the PPO had already been issued in favor of the said respondent number 6. The petitioner then approached the council court for modification or for further reliefs.
For execution of the...
Yes, for further reliefs, and thereafter a compromise arrived at between the petitioner respondent number 6, which has been recorded in the order dated 13 May 2025.
Lordship.
Right?
Yes, Lordship.
13 May 2025.
Page 89.
Passed in Miss Case number 31 of 2025 in Succession Case 34 2021. Stop. However, in spite of the deed of compromise submits, the respondent before had issued the impugned letter dated 4th August 2025, wherein it was stated that the PPO could not be issued in absence of any judgment and order to that effect. As such, submits the petitioner has been compelled to approach this court. Mr. K. Karmaphan, on behalf of the respondent number 4, has submitted that the family pension in respect of Shri Lee Rashman Lapang could not be released to the petitioner on the strength of the compromise in the absence of any other judgment order. He, however, submits that the matter, since the parties have reached a compromise, the matter can be disposed of at the stage itself by issuing directions based on the compromise arrived at between the parties. Mr. B. Kiriam, appearing for respondent number 6, has also concurred the submissions and submitted that the respondent number 6, who is stated to be first wife, has waived all her rights and claims to the family pension or the term benefits of the petitioner. And having heard that counsel with the parties also examined the available materials on record, this court has also examined the order dated 13 May 2025 passed by the Supreme Court, wherein the deed of compromise, wherein has been wherein it has been given as follows: reproduce the entire order, very short order. This court has also perused the impugned order dated 4th August 2025, passed by the accounts officer of the respondent number 4 with respect to the family pension. Next paragraph. In the circumstances of the case, inasmuch as the parties have since reached a compromise, this court feels that there is no impediment for allowing the deed of compromise to be acted upon by the respondent number 4 in issuance of necessary pension payment orders in favor of the writ petitioner. So accordingly, it is ordered that the respondent number 4 shall process the payment and grant issuance of payment of term benefits and issuance of PPO and payment of term benefits as entitled to the writ petitioner expeditiously. Matter according stands closed and disposed of.
Highly obliged, Your Lordship.
Item number 12.
This is that family pension matter, Lordship, wherein the petitioner and her husband both served in the Assam Rifles and retired, Lordship. Now, petitioner's date of birth.
Affidavit.
Yes, Your Lordship.
Yeah, you have received, Lordship.
Yes.
I want to submit, Lordship, here that as per the CCS pension rules, Lordship, the eligibility criteria for grant of family pension is that it is to be payable to the spouse of the government servant or the pensioner, Lordship. And it is an admitted fact as per the records of the respondent that she is the spouse, Lordship. So other details may not be gone into, Lordship.
What's the hindrance?
There is a mismatch in her date of birth, Lordship. In her.
Oh yes, how Lordship. That mismatch can it be reconciled?
Lordship. But it's an
admitted when you are how old?
Lordship, as per her husband's in her husband's service record, Lordship, there is no problem, Lordship. But in her own service records, it seems that her date of birth is 1962, Lordship. That would make her marriage 7 years, Lordship.
When she was 7 years old.
7 years, Lordship. But as per the Prohibition of Child Marriage Act 2006 also, Lordship, this section 3 says that it's voidable, Lordship, not void. So only...
No, we are not into whether marriage is void or not,
Lordship.
voidable.
Only point
being she is the spouse, Lordship. It's admitted, is born out of the records of the respondents themselves, Lordship. There is no dispute. And being the spouse, she is entitled to receive family pension, Lordship.
Very strange case.
Lordship.
Yes, Dr. Muzika. Allow the pension?
But we want to file a rejoinder because
Lordship, may not be required, Lordship, if based on my sub, may not, we'll file, Lordship.
Yes?
May not be required, Lordship.
What do you say in the affidavit?
My affidavit was said in para 6, kindly see, madam.
Yes.
The application dated was received from the petitioner stating that her husband expired on so and so, and she is not getting family pension due to mismatch of her name and date of birth in service record, and requested for amendment of date of birth as 1962 instead of 1954. However, as per service record, she got married with ex-Nike so and so on 1970. Therefore, as per her request, if the date of birth is amended to 1962, her age would be 7 years 8 months at the time of marriage, which is not permissible under section so and so. So and so.
Respondents are admitting, Lordship, that they were married, and as per the service record of the husband, Lordship, her name is there.
7 years and 8 months.
7 or 8 months.
Can the court condone that?
Lordship, I'm only submitting that being the spouse, Lordship, she is eligible for receiving family pension, Lordship.
Your dear Aadhaar card 62.
Lordship.
Well, we have to maintain records. They can get any other document, my lord, from a court order or something that to the date of birth is like this one.
Lordship, this record was available with the respondent, Lordship, all this while during her service record, Lordship, and they did not object. They did not point out that there is an anomaly, Lordship. This is the fag end of her life, Lordship. They are bringing this fact out, Lordship, and it was with them all the while, Lordship.
Very strange case.
And also it appears, my lord, kindly see page 9, my lord.
Of the affidavit?
Yes, my lord.
Yes.
Bulbul wife, date of birth 54. Jayaprakash son 673. See, 62 child is born at the age of 11 years.
A correct date of birth 54 then. 54 is a correct date of birth.
Seems to be, Lordship. Lordship, what had happened, Lordship, here, if I can brief, Lordship.
And she got married when she was nearly 16
Lordship,
only.
When she was very...
Okay. But then at that time, you changed your date of birth to 62, then your son was born when she was 11 years old.
Also.
Then?
Now they are insisting us, the petitioner, to change. Now what will happen is that if she changes her date of birth, Lordship, then her own pension will be stopped, Lordship. Because her pension is paid.
That is the problem.
Both ways.
You can't have your cake and eat it too.
Lordship. And these service records, Lordship, what happened was she was on a temporary capacity working in Assam as cleaner, Lordship. And when a permanent post came, Lordship, she is an illiterate woman, Lordship. Her officer enrolled her and recorded her details, Lordship.
What to do, Dr. Mazika?
But the best thing to keep this record straight, my lord. But she'll have to choose one thing, my lord, either 54 or 60. You can't have two birth dates in the same government records, my lord.
In the same department of some rifles.
Yes, my lord. For one pension,
she's
54.
She's born 54, and for availing the pension of
husband,
family pension, she's 62.
Lordship, I may humbly pray, Lordship. This record she has not brought from outside, Lordship. This is available with the respondent,
But then
Lordship.
how will they reconcile it, Lordship? Can the court allow also to, that can do, okay, fine. You have two date of birth, which is different by 8 years.
My humble submission, Lordship, at this point is, Lordship, that being the spouse is eligible for, and she will get this family pension as soon as she is alive, Lordship.
Overlook everything.
And
you're asking this court to overlook everything. The only fact is that she's undisputed, that is
Lordship.
She's a spouse.
And she will receive this family pension as soon as she is alive, Lordship. And after that, there are no other claimants, Lordship. And she is the spouse, Lordship.
They would take some pain also, my lord. To throw everything on the department, my lord.
Lordship, taking pain, we have taken pain, Lordship. We have made.
What is the amount of pension you're getting now from your own service?
Lordship, I'll have to take instruction, Lordship, but as per the instructions.
And how much will you get from them? Your husband's pension. So then you can choose the better of the two.
Lordship, but she will be deprived of a family pension, Lordship. In that case,
she's getting her own pension. So should be happy with
pension, that. If the family pension of the husband is larger, you take family pension given your own family pension. Your own pension will be larger, naturally. Yes, after this has been filed, Mr. Pandey please is allowed to obtain further instructions. Yes, sir.
13,
some disability pension. In this matter, affidavit has been filed, but then there are several other connected matters in today's list, my lord, where pleadings are not complete. So if all this batch is actually decided together, my lord, it may be
There are
convenient.
3 cases, 681, 62, 63. How many are there? Have you filed affidavits and all?
My lord, no, my lord, item 23, 24, then again, my lord, item 20, 21, 22, 23, 24, then 33
No matters were
and
called out, my lord.
34, my lord.
The matters were called out. In this matter, we filed affidavit.
Okay, we'll call out the matters, yes. You filed a rejoinder here?
No, my lord.
Yes, sir.
My lord, I wanted that if all the cases are actually heard together.
Yeah, we'll
the
do
same
that,
issue,
yes.
more or less.
The pleading with
Submits that after 68, this is 681. What about 682, 683?
We have not filed, my lord. I'm praying for some time.
Yes, 681 and 681 only. What link lang? In WC 681, the BPATAC submits that no rejoinder will be necessary to affidavit filed by the respondent. Stop. And the next 62, 63.
Praying for some more time.
Is this it after this? What is this?
682 and 683 are, my lord, relating to promotion, my lord. But then these are persons, my lord, affected by HIV. So whether, my lord, such persons on the ground of having contracted HIV can be deprived from promotion.
Why is it linked together?
It's not listed together, separately. Item number 14, 15.
14.
Item 14 and 15.
681, 681, that's also was a matter for hearing. Okay. Then 682.
I'm praying for time, my lord, for affidavit. 15 also.
15. 682. As prayed for the 2 weeks time after affidavit. Similar order in 15. Yes. Next 6.
Yes. Pray for 3 weeks.
Okay, 3 weeks time. Yes. What? How long had you order? Yes.
Obliged, man.
16,
Wait, please, your lordship.
There's affidavit.
Your lordship, yesterday we could not effect a service on the petitioners, your lordship. So I'm praying for time. We're filing it in the course of the day.
You receive copy?
No, not yet.
I'll serve them a copy now, your lordship.
What's the matter about?
That non-payment of contract bills, my lord.
Yes, MS said in country, then the GA submits that the affidavit on behalf of the respondent transport with the list after 2 weeks for the joiners in.
Yes.
Item number 17 as well, your lordship.
17.
Yes, your lordship.
17. Was it both of them?
16 and
same?
17, your
16,
lordship.
same petitioner. Okay.
Yes, your lordship.
18,
Obliged,
your lordship.
Yes, Mr. Watson.
Your Lordship, my senior was supposed to appear online, Your Lordship. I think she's still on next, Your Lordship, in the other court. Oh, there she is.
The same problem here also, my lord. The clause 70. Clause 70.
Yes, you give the name.
My lord, last occasion.
On the last date, my lord, I have given additional 3.
No, that's what. Give the name.
We have given the name to them, my lord, on the last occasion.
RP
No, they have given a separate list, my lord.
Rajiv Kumar Jain.
Akhilesh Kumar.
No, my lord, RP Singhal, my lord.
It's not here that in the additional list give one Rajinder Paul.
Yes, that is RP Singhal.
Serial number 1, Your
Rajinder
Lordship.
Paul Singhal.
Oh, you agreed with him?
Yes, my
No,
lord.
my lord.
No.
From our list, my lord. We have given 5 names.
Where's your list? Okay.
My lord, I do not know which 5 names.
Given earlier occasion.
Let's see the name.
One is Judge, my lord, Justice B.D. Agarwal. That can be removed, my lord. The remaining 4, any one of them. Serial number 4 is Justice B.D. Agarwal. That can be ignored.
Okay.
1, 2, 3, 5, anyone.
My lord, from this list, already 2 judge appointments have been made, my lord. Vijendra Kumar Jain, your lordship has already appointed, and I think
Yeah.
MC Parvar also. Akhilesh Kumar is also appointed in some other matter.
So appoint Satish
We
Chandar.
had given.
Yes,
No, my lord.
Satish Chandra can be appointed.
My lord, we have given the extra additional list. From there, we suggest Ravindra Paul Singhal, if your lordship is pleased to appoint, my lord.
Even if the department is not comfortable, my lord.
They're not comfortable with him. Then court will appoint.
Yes, Lordship appointed.
My lord, then let this matter come up.
No, we'll appoint this Satish Chandra.
Akhilesh Kumar, sorry, my lord. From their list, then Akhilesh Kumar, number 1.
Akhilesh Kumar. Yes.
But we suggest, my lord, Ravindra Paul Singhal, that was suggested to the department also.
Yes, anyway, from the list provided by the parties, from this part, DSG sub this court hereby appoints or has identified Sri Akhilesh Kumar to arbitrator. That is to be the sole arbitrator for the for this matter, stop consent and other requirements to be obtained by the registrars.
My lord, in the event Akhilesh Kumar is not having the thing under 12.
Yes, they have to send the consent and other requirements, yes.
19.
As is done in other cases.
Obliged.
19.
This is a contempt application, my lord, for non.
My lord.
Well, here what happened, my lord,
SLP
the SLP has been dismissed, my lord. We obtained for some more time.
Dismissed, my lord.
We'll have to implement it.
Dr. Mozika
4 weeks time
that the order will be implemented in time. She prays around 4 weeks time to obtain instructions. Yeah.
20.
Obliged, my
20.
20 again, disability pension, my lord, again. 20 affidavit has been filed, but then 21, 22, 23 and 24, the replies are not yet received, my lord.
Yes, is all similar?
Similar, my lord, same issue.
Yes. In WBC number 26, affidavit has since been filed. However, affidavit is still awaited in the other connected petitions. This after 3 weeks. Yes.
Till 28.
Yes.
Till 24, my lord. Till 24, 25 to 28 are, my lord, relating to non-communication of ACR.
So, go to file affidavit. Get the dates, my lord.
Yeah, 25 to 28.
Non-communication of ACR, my lord.
Yes. Affidavit for the 3 weeks time allowed by affidavit. List after so 3 weeks, yes.
29.
Obliged.
29.
Hey, please, your lordship. We require some more time, your lordship, to file rejoinder.
How much time do you feel?
2 weeks time, your lordship.
No,
This
how
is the
many-
second time. your
Second
lordship.
time. Yes, MS Armandai prays was allowed for the 2 weeks time to file rejoinder.
Much
This
better.
after.
30.
May it please your lordship. Lordship is a matter pertaining to compulsory retirement. So on the last day, they had to file the affidavit.
And did none appear last date?
Yes, lordship. My apologies, lordship.
Your lordship, we've received instructions. I'm praying for 2 weeks' time.
I've received instruction, your lordship.
Yes, sir. That's it. You know, can read for
1 to 5 and 7, your lordship.
1 to 5 and
7.
7 and MS you for sub for
6, your lordship.
pray for not further 2 weeks time for activities. Just that after also.
Much
Obliged,
obliged.
lordship.
1.
May it please your lordship. Lordship, we've received the affidavits in opposition filed by the respondents number 2, 3 and 4. Lordship, we required 2 weeks time to file our rejoinder.
2,
3 and 4. Yes,
What
lordship.
5?
5 and 6 have not filed their affidavits.
Please, your lordship, I'm appearing we have a respondent number 6. I'm praying for some more time to file the counter.
5.
affidavit.
So Mr. S.M. Submits that affidavits on behalf of respondents 2, 3 and 4 since received.
Yes, lordship.
He prays for the rejoinder.
Yes, lordship.
He prays for not to file rejoinder.
To the affidavits of 3 and 4, lordship.
MS pays normally for 5 and MS T Supringa for 6. I will pray for not further 2 weeks time to file affidavits. This after 2 weeks for rejoinders and for affidavits by the remaining respondents.
Deeply obliged.
32.
The first time it's come, 3 weeks.
Which one?
It's just the second time it's come.
33.
3 weeks for the time it's been.
3 weeks.
Yes, so 3 weeks for affidavit, yes. 33?
33, 34.
16, yes. And 34. So, Mr. Pathak, you got a monopoly in unauthorized cases now.
35.
Yes. Yes. Right.
Lordship, kindly turn to page 6 of our affidavit of service. We have effected dusty service, my lords. Page 6, my lords.
Why dusty service? Allow dusty service.
Then? No, my lords.
You can't do that.
My lords, but she has received it, the branch manager.
This is feeding our account.
Yes, my lords.
You can't issue notices through, unless the court allows you dusty service. Though there's no order for issuance of dusty service on the respondent number 1. MSS Sham, however, has submitted that has filed an affidavit indicating service on said respondent.
We have the receipt, my lord's acknowledgement of the petition as well. She's received the petition as well, my lords.
To take also petition directed to take steps by registered AD also.
My lords, 1 week's time, my lords. Kindly, 1 week's time.
1 week's time.
Grateful, grateful.
It's up to 1 week.
36.
Please, your lordship, steps have been taken to serve upon respondent number 4 and 5.
Lordship, I'm entering appearance on behalf
4 and 5.
Your lordship.
Respondent number 4.
Some 1, 2, and 3, my lord.
5 is whom?
It's the same of Kairim, same ship, your lordship.
5 Dorbar Snong Mandriang.
Your lordship.
Yes, MS bidding the other appearance today on behalf of respondent number 4. However, officer indicates that service is not complete on respondent number 5 stop. Want to file affidavit?
I'll seek instruction, your lordship.
What about you?
Yes, my lord, I'll file after.
You appeal with the council?
Yes, my lord. 1, 2, and 3, my lord.
Yes, MS OI Bank for 103 praise for the 2 weeks time to file affidavit. Similarly, respondent number 4. Just up to 2 weeks for. You want to obtain status?
Your lordship will be
Yes,
filing.
up to 2 weeks for further order stop. The petitioners also submitted to obtain, allowed to obtain status of service on respondent number 5.
Your lordship.
And to file service affidavit necessary for the next date.
Your lordship. Highly obliged, your lordship.
Second call 6.
Yes, given the judgments to.
Yes, my lord. Well, the difficulty, my lord, they agreed to this, my lord. Now the former Chief Justice has given a consent now to recall the point.
Doesn't look proper.
My lord, my respectful submission would be, my lord, this paragraph 40, my lord, paragraph 41, my lord, she may kindly. The qualification is very apparent, my lord.
You can assist them engineer.
My lord, the qualifications.
You can get assist them engineer.
My lord, the qualification of an arbitrator should be an engineer. Should have an engineering degree, my lord. The qualification of an arbitrator, my lord. So, my lord,
this is different circumstances. This case.
My lord, what I am submitting, my lord, this is only a prospective, my lord. He was considered to be a prospective as per the, my lord, the provision, my lord. If I lead your lordship to pay this 11.8, lordship has already, I have just stated that, my lord, 11.8, my lord. That specifically says that before appointing, my lord.
You see, you have to pay for your errors.
My lord,
you ask a retired Chief Justice who has given his consent.
Yes, my
lord. Now you're filing his application. You have to make him a party then.
So, my lord,
see what will happen.
My lord, actually, my lord, if you go
Who's
by
your party? It's a government company.
No, my lord.
is engaged in what?
He's a contractor, my lord. He is engaged in the works of, my lord.
Then it will the thing that the arbitrator engaged in engineering system. That's all.
My lord, the qualification of an arbitrator should be have an engineering degree, my lord. That is what I am submitting, my lord. And my lord,
we reject your submissions.
My lord, I will just
submit that. Yes.
Yes, my lord. I will just place one judgment of iron and steel, my lord. Lordship may kindly, my lord.
Had they not consented on the first day?
Yes, would have never.
My lord,
who has created the situation?
My lord, I sincerely apologize for that, my lord. That was on that day, my lord. It's a virtual hearing, my lord. My.
Why don't you come physically? If you're so interested to come now to pursue this hearing,
yes,
to change the arbitrator, then why didn't you come personally on that day?
My lord, actually, what is that?
For appointing arbitrator?
My lord, actually, on that day, we seek short time for, my lord, rejoinder, my lord.
That's not correct.
That's not correct. We'll go back to the YouTube recording.
No, my lord. What this is recorded in the order, my lord. We sought time for, my lord, filing of the rejoinder, my lord. And my lord, if lordship, if it is there in the order, my lord itself, my lord. And my junior counsel could not follow the virtual proceeding, my lord. That is why I sincerely apologize for that, my lord. My lord, page 1117, my lord.
Appointment is not there.
I sincerely apologize for, my lord, the inconvenience caused to the court, my lord. Sir, Nasir Learned Counsel for the petitioner today has prayed further time to file rejoinder.
Yes.
But however, on the suggestions, Mr. Vice so-and-so, retired Chief Justice Learned so-and-so, Chief Justice so-and-so, Mr. S.R. Nasir Learned Counsel for the petitioner has no objection. My lord, what has happened, my lord, he could not follow, my lord. That is what we have been submitting, my lord. But before appointing, my lord, the consent of the parties is also required, my lord.
We asked. Is the consent what? We didn't ask him. He was a counsel appearing.
My lord, he could not follow.
Is your party personally present here?
No, my lord.
Then you take consent for you placing a judgment.
No, my lord, definitely, my lord.
We can't have this conduct.
Yes, my lord. We sincerely apologize, my lord.
Apologize to me. What will happen? To the court will happen. You go and apologize to the retired Chief Justice, obtains consent, is given in writing by email and by letter. You take instructions, notwithstanding all your Supreme Court decisions, you take instructions that we can modify it or to the extent that in recognition of the apology and the requirement that you state, even though this court has serious reservations about whether that whole clause will go, it's a serving officer who has a degree in engineering. If the whole clause goes, serving officer, the qualifications also goes. Notwithstanding your submission, you take instructions.
Such qualifications are relevant till the moment it comes section 34, there are judicial officers, my lord. 37, there are judicial officers. They can ask their technical officers everywhere, my lord.
Mr. Your name? Sorry.
G. Alam, my lord. G. Alam, my lord. G. Alam.
Yes, Mr. G. Alam, today, after hearing at some length, Mr. G. Alam prays that we have to obtain instructions. The obtaining of it has been necessary to obtain instructions with the fact that the order for appointment of retired Chief Justice Arbitrator was with the consent of the petitioner, who is now seeking for modification the order. Stop. Yes, you tell your party. You say that you get as an engineer. That's it. Yes.
Second call for.
At least up to 2 weeks.
May I pray for date, my lord?
You take the date in court.
Yes, my lord.
Second call.
If you are mindful in conducting your cases, then it will happen. And you can't embarrass.
Yes, my lord. I sincerely apologize. This is what, my lord, actually.
Yes.
All my lord.
Embarrassment for the court. Embarrassment for.
Yes, my lord. Yes. I understand, my lord.
Yes.
Wait, please.
Yes.
This is that section, Order 41, Rule 11 application.
Order 41?
Sorry, it's Order 7, Rule
11.
Yes. Yes.
Because as far as this matter is concerned, this matter was argued threadbare about more than 6 months back.
Yes.
And
why was it postponed then?
Because as far as we are concerned, we had filed the respondents who are applicants in this matter had filed their final bullet submissions on 19th of August 2025.
What happened after that?
My lords, however, I believe the election petitioners are yet to file their final submissions in this matter.
No, as a matter of fact, my lords, we had also filed it, but the issue was by then it was when the matter came up before my lords, your lordships would recollect, my lords, that an observation fair for my lords that it's been so long since the matter has been heard that your lordships probably wanted the matter to be refreshed. Limited issue involved, my lords.
This one's is not on presentation, correct?
No,
it is on presentation.
It is also on presentation, but
or defects.
Yes, my lords, because on
defects on presentation. Is it under 81 or 81 or 81.3?
Both are 81, my lords. One is 81 subsection 1, that is presentation, and subsection 3 is the question of giving a true copy.
See, if it's 81.1, then means if presentation is defective, it cannot be cured. But 81.3, then it can be, if substantial compliance is there, then the matter can go ahead.
Substantial compliance, that's what we had argued.
So,
the law is that it has to be compliance.
So, belows, as far as this matter is concerned, section 81, as per section 86 of the Representation of People.
Okay, no, you break arguments in two parts. Okay, first 81.1, whether presented in proper form and before the proper officer. And second part, you can break it to 81.3, whether it's defective or the copy is served, or whether there's been substantial compliance. That's all.
Yes.
Before my friend starts, if I can just point out, this same issue came up, at the initial stage when the matter was argued. So, insofar as compliance of 81.1 is concerned, your lordships have already passed a judgment in another matter, where lordships have held that it is a mixed question of law and fact. So, this cannot be decided at the stage of 711.
Yes.
Now, insofar as 81.3 is concerned, what had been argued at length by my learned friend on the last occasion was of that there is non-compliance
True copy.
of 81.3. Because they say the copy is not the same.
Yes. Yes.
So that this is the primary issue, Milits, and what we had pointed out is some judgments of the Honorable Supreme Court, Milits, as a matter of fact, which the law which holds the field is that it has to be of substance and not of form.
The judgment say that if it's 81.3, yes, but 81.1, no.
81.1, Milits, as your lordships have held in that other matter.
But I don't think at this stage we can. We can't go for, taking evidence to date the day now. It'll take another 1 year.
That's another issue. But because as far as the present case is concerned, what we are saying is that 81.1 is an issue in this matter, but that may require evidence. And for Milots, because there is an additional defect in this matter, that is in respect of 81.3.
Okay, Mr. Pandey, suppose Ramphasai, we hold that there's been substantial compliance. So 81.3 we can disregard and say that is in proper form. That the service of notice, true copies, whatever. And then be confined to 81.1. Then 81.1, what is your case?
No, Milots, as far as this matter is concerned, 81.3 compliance is not there. So there is no substantial compliance.
The court is assuming, it's not saying that we will rule, but suppose prima facie is okay, because the court can rule that if, even the slight defects here and there, substantial compliance is there, then the election petition is in proper form and service has been accorded as per the act. Right? And 81.1, there can be no excuses if it's not.
No excuses. There is no question
if Mr. Paul's client fails on 81.1, then the election petition is thrown out.
Yes.
Absolutely.
Yeah, then we 81.3.
But here, Milits, the primary thrust of the application under 711 is Milits under 81.3, not under 81.1.
That's one.
So,
because 81.1, your lordship's judgment will hold, where your lordships have held that the issue of 81.1 Milits has to be only decided by Milits evidence. Whether I was present at the time of presentation of the application, Milits, that cannot be decided on the basis of pleadings. That would have to be brought out by evidence.
Yes. No, one case already been decided. You see, there's one judgment, it's not been reported, but it was past few months ago, where one was dismissed. I think Mr. Pandey is the lawyer there only. It's dismissed on the ground of presentation. That's Sora case. Yes.
It was dismissed on
Yes.
that ground. So, as far as that stage is concerned, we are yet to reach that stage of 81(1) of taking evidence. If we can, at the very threshold, dismiss this petition, if the petition could be seen from the perspective of 81(3), if they do not cross the hurdle of 81(3), then we will not reach at the stage of 81(1). Both stages are relevant in this matter, but first 81(3) has to be crossed to reach 81(1).
Now, what is the fatal flaws that you have detected? You see in the 81(3) application.
So, in this
the
regard,
81(3), yes.
Yes, in this regard, I would beseech your lordship to have the final submissions that I had filed on 19th of August 2025. Just to refresh your lordship's memory of this matter. Because what has happened in this matter is two important aspects.
To be very candid, I don't want to waste judicial time with regard to these matters have been taking the attention of the court long enough without any just on presentation, and it doesn't even cross the threshold of being even argued on merits. Yes.
The only reason why we had pointed this out is, I had said that there should be some judicial pronouncement, authoritative judicial pronouncement from your lordships insofar as 81(3) is concerned. One of the initial objections that we had taken, my learned friend would have to first cross that, because the law provides, that they would have to seek leave from your lordships to file this application.
Right.
In this case, admittedly, there is no leave that has been sought. So this application under Order 7, Rule 11 has been filed.
Then we do one thing to put, quietus the matter. You file your bullet points within 10 days, and we will decide. Without further arguments. Yes. But if the defects you point out, you put them in your bullet points, we'll examine.
Yes, so what I propose to do that in the interregnum very recently, a judgment on the same issue has been passed by the Honorable Guwahati High Court on 81(3). So I will also revise my written submissions and add subsequent judgments.
Okay, you revise one of them. Yes, parties submit. They may be allowed to file written submissions within 10 days. Is it all right? Yes.
Yes, sir.
10 days.
Yes.
Yes. Additional written submissions, because they have.
Yes, additional.
Have already been.
Yes. The applicant 7 party submit, that may be file written submissions. No, sorry, Mr. Paul prays he will allowed to file the submission on behalf of the petitioner. Mr. Pandey prays that he also will be allowed to file additional written submissions on behalf of the respondent. Stroke applicant.
Yes.
Applicant bracket 711 CPC applications. Yes, after 10 days.
Hearing. Supplementary.
Put an end to all this, otherwise.
We'll have something to bother your lordships with during the vacations.
Yes.
All right.
Yes.
Hearing. Supplementary.
Result.
Contonement matter.
Yes.
A cantonment matter, my lord.
Yes.
Lordship, I have taken your lordship through the order passed by the appellate authority, my lord, and impugn order, my lord. May I take your lordship?
Before you start, can just give this court 5 minutes. Yes.
Yes, my lord. Or your lordship may have it at 2 because.
No, but I'll come back in 5 minutes.
Yes.
Yes. Yes.
May it please. Lordship, I was placing
Yes.
the order passed by the appellate authority, my lord,
Where is that?
at page 246, my lord, which was held in my favor, my lord. Page 246, my lord.
Yes.
If I place, my lord, this is the order dated 26 November 2018, 247, your lordship will find the date.
Yes.
Then, my lord, the facts are recorded at page 248, paragraph 6, my lord.
Yes.
In fact, paragraph 5, my lord, if last 6-7 line of paragraph 5.
Yes.
While its order dated 2nd November 2018, Honorable High Court of Meghalaya directed that considering the submission by the learned counsel to parties, especially from the submission of learned counsel of the petitioner, is not going to insist on personal hearing, the appellate authority may take up the matter on the basis of written argument and affidavit filed by petitioner. In such circumstances, the appellate authority is directed to dispose the appeal within a period of a month by speaking order. In compliance of their own direction, the EBIT order is being passed, my lord. Now, paragraph 6, my lord. The order was, this Honorable Court directed the appellate authority to pass the order. My matter was pending for quite some time. Before going into the merits of the appeal, the factual matrix of the case as evinced from the documents on record of the case is stated as under. Plot of land, 0 point survey, etc., my lord. The history is captured in the paragraphs 6A, B, C, my lord. And my applications, your lordship will notice that has been pending with the authorities for a number of years. All those aspects, after having considered, my lord, at page 255, paragraph 11, my lord, the direction has been passed. Kindly note the direction, my lord, and kindly see whether the order passed by the authority is in terms of the appellate authority or not.
Yes.
The appellant to give a fresh notice of re-erection of bungalow number 33 under section 235 of Contonement Act, together with complete building plan and sketches, details of material to be used, as well as detailed cost estimate erection to the Contonement Board, Shillong, within 1 month from the date of the receipt of the order. Appellant shall render an affidavit of undertaking regarding effecting the erection of the re-erection of the said bungalow number 33 on survey number 32 of Shillong Contonement at reasonable cost as per its original specification and character of Assam type building, with no change in the plinth area and cubic capacity of each room as and when there existed. Now, my lord, kindly mark, the undertaking shall also state the appellant shall cooperate in peaceful resumption of the lease hold property after expiration of the said lease period in 26 to the government of India without seeking compensation of the expenditure done by the appellant or re-erection of the building as per sanctioned building plan. I have given this undertaking also, my lord. The Contonement Board shall process the case for necessary NOC of DEU. The Guwahati, under the Contonement Act, DEO of Guwahati will process the case in accordance with the provisions of 238(3) of Contonement Act within time limit of 1 month stipulated therein. DEO of Guwahati Circle shall report to Contonement Board under 283(t) comment upon the issue of requisition of property with respect to a station zonal plan, the status of resumption proceeding, as well as security related observation of LMA station dated 24th August 2017. Upon receipt of report from DEO Guwahati's Contonement Board, Shillong will consider the permission for erection or re-erection of bungalow through Contonement Board resolution and detailed minutes, especially the aspect of incurring substantial expenditure by the appellant in re-erection within a period of 1 month. My lord, the direction is to board to consider this aspect and pass and give a detailed minutes, my lord. Shall consider the violation of provision, etc. My lord. Now kindly see the impugn order at 246, my lord. Oh, sorry, 255.
Again, you just see just now.
Oh, sorry, I was taking your lordship to the impugn order, which is important, my lord, 454, my lord. 454. Now kindly see 454, 453 is there, my lord. 454 is the order passed by the board after the matter has been remanded back to the board. 454.
Resolution.
Resolution. Matter was widely deliberated by the board. Board took note of the stay order in the acquisition proceeding by Guwahati in communicated DO circle letter number so and so, that LMA wide letter number dated so and so, my lord. This is nothing to this DO matter of land acquisition has nothing to do with my bungalow, my lord. But be as it may, my lord, that has also been. Mr. Parasmal Botra, elected member, is of the view that sanction is to be issued with condition keeping in view of the order of the appellate authority dated 26 November 2018. Board finally considered and rejected the building application, my lord. No reason whatsoever, my lord, is given, and the appellate authority has, lordship has seen at 255, appellate authority has considered the matters, it has laid down the guidelines, it has issued direction to the board that it will consider and pass the order with certain undertaking, my lord. So the order of the board, my lord, my first ground at this time, my lord, is completely non-speaking and contrary to the order passed by the appellate authority. Appellate authority has said, consider it and grant it. And what will you consider? You will consider that whether the security concern, acquisition, etc. My lord, if your lordship kindly see 255 once again, my lord.
Yes.
256 C, my lord.
Yes.
Cantonment Board, Ceylon, shall process the case for necessary NOC of the DO Guwahati Circle under Contonement Act. DO of Guwahati will process the case in accordance with the provisions of 238(3) of the Contonement Act within the time limit of 1 month as stipulated therein. DO of Guwahati shall in report to the Contonement Board under section 283 specifically comment upon issue of requisition of the property with respect to a station zonal plan, the status of resumption proceeding, as well as security letter related observations raised by the LMA wide station Shillong letter dated 24th August 2017. Upon receipt of report of DO Guwahati, Cantonment Board Shillong will consider the permission for re-erection or erection of bungalow through so and so, my lord. So the order is, my lord, clear and binding, my lord. So therefore, and the order passed by the appellate board is completely divorced the reason. No grounds have been assigned, my lord, and it is in violation to the order of the appellate authority, my lord. At this juncture, my lord, so therefore my submission is that order can be set aside with the direction to the board to pass the regional order, my lord, in terms of the appellate order. That will also satisfy, my lord, my case at this juncture without going into the details, because it is in violation to the Cantonment Act, my lord. Now kindly have a look at the Cantonment Act at this point of time, my lord. 238, my lord, section 238.
Yes.
Because there is a reference to Cantonment Act time to time.
Yes.
But before I take your lordship to 238, kindly have a look at section 340 for a moment, my lord.
340 is appeals from executive orders, which this appeal of yours also was settled by GOC and C and setting the appeal in 340, right?
340.
Yes.
Yes, my lord. Only thing is what I'm trying to highlight is, my lord, 344 is that the finality of the appellate order.
Yes. Yes, for 340 was final.
Every order of the appellate authority shall be final. So when there is an order passed by the appellate authority, my argument is this, my lord, directing the board to consider my case in the light of certain directions. Board by one line cannot refuse to obey the order of the appellate authority which has attained finality under section 344, my lord. And by non-speaking order, it has rejected.
No, finality at 344, that is not in question here. The only thing is that certain directions were issued by the appellate authority and has not been carried out, that's all.
So what the submission which I have, my lord, is this, my lord, that once the appellate authority's order is final, it is binding on board, it is binding on me, my lord. I have not challenged it, the other side has not challenged it. So when board is bound by the finality of the order, board can't say that I will not follow the order of the appellate authority. That is the only submission.
This order of the appellate authority was passed which date?
It was passed way back in 2018, my lord, and if your lordship will have the list
And
of
the
dates,
Contonement Board order is
serial number,
dated?
your lordship will find 26/11/2018. Serial
The
number 31.
Appellate Part 26/11/18.
11/2018.
And the order of Contonement Board is
10th October to 2019, my lord.
So what happened between 19 and now?
I will come to that also, my lord.
Yes.
First, let me.
I was under the impression that is they are fresh
I
orders.
will take your. Yes, my lord. So first argument which I am placing before your lordship is that the order of 10/10/2019 is per se illegal. It is against the order of the appellate authority.
Granted.
And it is second argument, and it is non-speaking unreasoned order.
Okay, that you don't have to
This
see.
is my first.
It's apparent.
The second argument which I have, my lord, second argument which I have, it is also contrary to the statutory provisions contained in section 238. Kindly see section 233. Kindly see section 238, my lord.
Yes.
238, your lordship has section 238, power of board to sanction or refuse, my lord. The board may either refuse to sanction the erection or re-erection, as the case may be, of the building, or may sanction it either absolutely or subject to such direction as it thinks fit, to make it in writing in respect of all or any of the following matters, namely. So these are the board has been entrusted with, my lord, to grant sanction or re-erection, or may absolutely and subject to directions below. So the board has to consider my application in terms of section 238.
Absolutely, yes.
And kindly see 238(2), my lord.
Yes.
The board may refuse to sanction the erection or re-erection of any building on any ground sufficient in the opinion of board affecting the particular building, my lord. The lordship has seen the impugn order. There is no whisper.
Contrary to 238(5). Yes.
Yes, my lord. And now 238(5), my lord.
Yes.
If the board decides to refuse to sanction the erection or re-erection of the building, it shall communicate in writing reasons for such refusal to person by whom notice was given, my lord. Lordship has seen that the order is completely non-speaking, no reasons have been given, only one line is saying that decline to sanction.
Oh, you went and filed a suit.
Now I will come to that, my lord. This is
come to that. Okay, we are over that 2019-18. Now come to why you went and
coming to the delay part, my lord. Coming to the delay part, your lordship has seen that the first your lordship will have the order of your lordship of 2019, my lord, which is your lordship will find at serial number when the impugn order, I went before this and then I filed a contempt petition, my lord, 456. Your lordship will have 456. Kindly have page 456, my lord, at 457, my lord. This is I filed a contempt petition because I found that the order passed by the board is in violation to the order of this honorable court, but this honorable court said the contempt is not the remedy. You take up the fresh writ. My lord, kindly see this contempt order passed by your lordship on 26 November 2019, and kindly appreciate the plight of the petitioner who is running from pillar to post to get the sanction order despite everything in his favor, my lord. Now 26/11/2019, my lord, has been filed by petitioner alleging that have deliberately, intentionally and manifestly violated the order of 3/12/2018, order of 3/12/2018, my lord, which was taken into consideration and order was passed. Then the argument was advanced, my lord. The argument has noted that the board finally considered rejected the building application. Even though Mr. V.K. Jindal, senior counsel appearing for the rejection application raised the building has not been considered dealt with in fair manner, this would amount to contempt of the court. Court is not convinced with the aforesaid argument or direction, even if it was directed, the control shall consider the matter. It also does not amount to saying that application shall be granted. In fact, court tells the petitioner if is any aggrieved by decision, may approve the appropriate. No case for contempt. The petitioner is dismissed while reiterating the aforesaid as the petitioner to assail the order passed by board, if so advised in a fresh writ petition, my lord. So the lordship granted liberty to the petitioner to file a fresh writ petition, my lord. On the advice, my lord, I went in suit, my lord. And in suit, my lord, if your lordship will find My suit was filed in 2020, my lord. Immediately after this order, suit was filed, my lord. There was some assurance given by the board, my lord, not in writing, that your application will be considered, my lord. I withdrew the suit in 2022, my lord. 2022, waiting for the to fulfill the promise or the officials to fulfill the promise.
Where's the promise?
Promise
Is it in writing or is it just a promise
in
like
writing,
any other promise?
That's why I'm handicapped on that ground, my lord. Now I take it that there was delay of about 4 or 5 years in approaching on this honorable court, my lord. On this point, my lord, law is well settled, my lord. My right to property under 300A is protected by constitutional right, my lord. That right to have the habitation is also protected, my lord. Now, in identical circumstances, my lord, I have cited 5 judgments on right to property and continuing wrong. It is a case of continuing wrong, and therefore it is a case of continuing wrong, my lord. The limitation will not expire. Delay and latches will not come in my way, my lord. Delay and latches will not come in my way, my lord. The judgment, there is a judgment of the Honorable Supreme Court on this aspect, my lord. Though in the context of consumer case, but the court has dealt with this aspect in the citation is, my lord, 2022 4 SCC 103, my lord, and paragraphs are 13 to 21, my lord. Paragraph 13 to 21.
Yes.
Now kindly have this judgment, my lord. Paragraph 11 of the judgment, my lord, factual matrix. Kindly have the crux of the appeal resolves around the maintainability of the complaint, whether it is barred by limitation. NCDRC held that cause of action arose when municipal authorities asked the appellant to pay higher charges in the first instance. Thus, the complaint should have been filed within 2 years of accrual of cause of action. The appellant, however, has argued that cause of action is of continuing nature, since members of the appellant have continued paying higher charges as the respondent failed to provide the occupancy certificate. Section 24A of the Consumer Protection Act provides for period of limitation, period of lodging of complaint. A complaint to consumer forum has to be filed within 2 years of the date on which the cause of action has arisen. In the instant case appellant has submitted, since the cause of action is founded on a continuing wrong, my lord, the complaint is within limitation, my lord. Section 22 of the Limitation Act 1963 provides for computation of limitation in a case of continuing breach of contract or tort. It provides that in case of continuing breach of contract, a fresh period of limitation begins to run every moment of time during the breach of continues, my lord. This court in Balakrishna Saval Ram Pujari Mare versus Sri Dhyaneswar Maharaj Sansthan elaborated on what a continuing cause of action arises, my lord. I will just pause here for a moment, my lord.
Okay, why you advancing the argument of continuing wrong?
Why? That is why I'm grateful for the query, my lord. Why I'm advancing? Because my continuing wrong is that sanction plan, the plan is not being sanctioned. It was not sanctioned earlier also, and because of non-sanctioning of plan, my lord,
it was rejected in 2019.
No, it
ends there.
In 2019.
Then
it was 2019, but that denial and the wrong is continuing, my lord. Because of that, I am not able to occupy my residence, my lord. I think, my lord, if it would have come to an end, if my wrong is not coming to an end, it is a continuing one. For every day, I am being denied to residence or to shelter, my lord.
Denied to enjoy the property.
I am not able to enjoy this. So this continuing wrong is this wrong is there and it is continuing, my lord. And therefore, this 2019 denial, my lord, your lordship kindly have a situation where, my lord, I am the owner of the property. I have been wrongly evicted by the board, or my land has been acquired by the board illegally, my lord. I come to your lordship after 10-15 years. Your lordship, in number of cases I've held that is a case of continuing wrong because your right to property has been denied. So therefore, my entire argument is founded on that basis, and that is what the subsequent paragraphs have highlighted, my lord. Kindly come to paragraph 14. Kindly come to paragraph 14 of the judgment. Is for 3-judge bench In P.B. Gajendra Gadkar, my lord, observe that does the conduct of trustee amount to a continuing wrong under section 23? This question is this is the question which Petitioner raises for our decision. In other words, did the cause of action arise diem as claimed by the appellant? In dealing with this argument, it is necessary to bear in mind section 23 refers not to continuing right but to continuing wrong. It is very essence of continuing wrong that it is an act which creates a continuing source of injury, my lord. Kindly mark this: continuing source of injury is there and renders the doer of the act responsible and liable for the continuance of said injury. If the wrongful act causes an injury which is complete, there is no continuing wrong, even though damage resulting from the act may continue. If our wrong act is of such a character that injury caused by itself continues, then act constitutes a continuing wrong. In this connection, it is necessary to draw distinction between injury caused by the wrongful act and what may be described as the effect of the said injury. It is only in regard to acts which can be properly characterized as continuing wrong that section 23 can be invoked, my lord. This court held in the act of trustee to deny the right of Gaurav as hereditary worshipper and dispossessing them through a decree of the court was not a continuing, although continued disposition caused damage to the injury. Now, my lord, 15 in CWT, Suresh said two judges bench of the court dealt with the question whether defaulting return under the Wealth Tax Act. After taking into account, my lord, the court even the Ram Janmabhoomi Temple Trust judgment, my lord, even in that case also the issue arose whether deprivation of property is a continuing case of continuing wrong or not, and in paragraph 17, my lord, of this judgment, citing the Constitution Bench judgment, my lord, it was held that it is a case of continuing wrong. If your lord will have paragraph 17, my lord, of this judgment. The submission of Nirmohi Akhara is based on the principle of continuing wrong as a defense to plea of limitation. In assessing the submission, a distinction must be made between source of legal injury and effect of injury. Source of legal injury is founded in breach of an obligation. A continuing wrong arises where there is an obligation imposed by law, agreement or otherwise, continue to act or desist from acting in particular manner. My lord, kindly pause here, kindly mark. A continuing wrong arises where there is an obligation imposed by law, agreement or otherwise continue to act. So here there is an obligation imposed on the board to sanction my plan in terms of section 238, even in terms of the order passed by the appellate authority. That was not done, my lord, and therefore it is a case of continuing wrong, my lord. For a continuing wrong to arise, there must be first place wrong actionable, and my lord, assuming, my lord, that I do not, but the question would be, which will be falling for lots of consideration, is that my right to property will be taken away on the ground of laches on my part, because limitation doesn't apply to the writ proceeding. My right to hold property, my right to enjoy property will be taken away on the ground that there was a laches on my part. Your lordship has always held, even the Honorable Supreme Court, then the writ jurisdiction, my lord, your lordship has been liberal in considering the aspects. Technical rule of limitation will not apply. Yes, I am not denying that, my lord, your lordship will see, because I have given a detailed list of dates. I got the property way back in 2005. I contest, and then property was given to me after 15 years by the authorities, and that too under the order of this Honorable Court. I was not given the property. They have taken 15 years. Now they are raising the ground that, look, there is a delay of 3 to 4 years in approaching the court, and therefore your right to property is extinguished, my lord. Your lordship will certainly weigh the conduct of both the parties and see that whose rights are getting affected, my lord. So this is one part of the matter, my lord. The second, my lord, if your lordship will see this in the land acquisition matter, my lord, this is the case, my lord, of recent judgment, my lord, where, my lord, this is the citation, my lord. The second judgment is 2022 7 SCC 508, and the paragraphs are, my lord, 14 to 18, my lord, 24-25, my lord. 14, my lord, is the important 13, my lord. While the right to property is no longer a fundamental right, it is pertinent to note that at the time of disposition of the subject land,
Which judgment is this?
Paragraph 30. This is, my lord, 2022 7 SCC 508, my lord.
You give the same one again. Red law. Red law now, 7 years. Paragraph.
Paragraph 13, my lord. 13 to 18 and 24 to 25, my lord. My lord.
Yes.
While the right to property is no longer a fundamental right, it is pertinent to note at the time of disposition of subject land, this right was still included in Part 3 of the Constitution. Right against deprivation of property, unless in accordance with procedure established by law, continued to be constitutional right under Article 300, capital A. It is the cardinal principle of rule of law that nobody can be deprived of liberty or property without due process or authorization of law. Recognition of dates back to 1700 to decision of King's Bench in Tick versus Carrington and by in Wazir Chand versus State of HP. Further, in several judgments, this court has repeatedly held that rather than enjoying a wider bandwidth of lenience, a state often has higher responsibility in demonstrating that it has acted within the confines of legality, therefore not tarnished the basic principle of rule of law. When it comes to the subject of private property, this court has upheld high threshold of legality that must be made to dispossess an individual of their property, and even more so when done by the state. In Bishan Das versus State of Punjab, this court rejected the contention that petitioner in case were trespassers and could be removed by an executive order, and instead included in the executive action taken by state and its officer was destructive of basic principle of rule of this court in the state of UP versus Dharminder Singh. Lesser with the best of title has no right to resume permission extrajudicially by use of force from lessee even after expiry of earlier termination of lease by forfeiture or otherwise. Use of expression re-entry in the lease deed does not authorize extrajudicial method to resume possession. Under the law, the possession of lessee even after expiry of earlier termination of juridical possession and forcible disposition is prohibited. Lessee cannot be dispossessed otherwise than due course of law. In the present case, the fact that lesser is the state does not place it in the higher or better position. On the contrary, it is under the additional inhibition stemming from the requirement that all action of state and government authorities should have legal pedigree. Given the important protection extended to an individual vis-a-vis private property, embedded earlier in Article 31, now under Constitution under 300A, right high threshold, the state must, while acquiring land, the question remains, can the state merely on the ground of delay and laches evade its legal responsibility towards those from whom private property has been expropriated? In these facts and circumstances, we find this conclusion to be unacceptable and warranting intervention on the grounds of equity and fairness. When seen holistically, my lord, these, my lord, paragraphs after paragraph, my lord, are on this aspect of the matter. Your lordship, kindly take note, judicial note of paragraph 14 to 18 and 24 to 25, my lord, where, and kindly apply the law in the facts of this case, my lord. This property has been leased to me, my lord. This property I cannot use is because in dilapidated condition which was put to you. It is not in use of the board, my lord. I am in possession, but I can't enjoy the property. So this is how the continuing wrong is going on. My right to property, my lord, is taken away by the authorities, my lord, and they have to be fair, my lord. Paragraph 24, kindly have paragraph 24, my lord. And with regard to contention of delay and laches, this court went on to hold. Contention advanced by state of delay and laches of the appellant in moving the court is also liable to be rejected. Delay and laches cannot be raised in a case of continuing cause of action or if the circumstances shock the judicial conscience of the court. Condonation of delay is a matter of judicial discretion which must be exercised judiciously and reasonably in facts and circumstances of case. It will depend upon breach of fundamental right, remedy claimed, and when and how delay arose. There is no period of limitation prescribed for court to exercise their constitutional jurisdiction to do substantive substantial justice. In 12.13, in case where the demand for justice is so compelling, a constitutional court would exercise jurisdiction with view to promote justice and not defeat it. But, my lord, their argument is the delay. With greatest respect, my lord, my case is that I have a right to life. I have a right, my lord, and this right is inherent in right to life also, my lord, in Article 21. Article 21 also says right to life includes right to shelter, my lord. My shelter is being taken away. Dilapidated conditions are there, my lord. The lordship has seen. That is why the purpose of giving the list of date was to show that they have taken 15 years in handing over plot to me. Kindly see serial number 14 of my list of dates, my lord, and serial number 14 of my list of dates. I have been since in fact, your lordship, serial number 10, serial number, if they say that delay is in my part, my lord, the first order which was in my favor was serial number 9, when this honorable court set aside the land acquisition proceeding of the bungalow, my lord. That is the reason which I am suffering, my lord, because it's very difficult for them to accept the order of this honorable court, my lord.
Now the thing is, you never stated now how many years you've been out of the bungalow. It's uninhabitable.
I have been because I have, your lordship, even for sanction, your lordship has noticed, I have to come to your lordship's court thrice, and then your lordship directed the appellate authority to consider and pass the order in 2019. 2019, I got the order. I came in contempt. Your lordship said you file a fresh petition. Then I filed a suit because I thought that all the issues will get resolved. But suit was not correct remedy. I admit, my lord, that was not a correct remedy. And then 22, I withdrew it, my lord. 25, I have filed it. If your lordship will see, the delay, if at all, is for a period of 3 years. In fond hope, my lord, in fond hope that I will get my sanction without litigation. That was my lord, and on that ground, my lord, I have cited 5, my lordship, kindly take note, I will not burden your lordship with the paragraph, but only I have cited, my lord, 2224 SEC 103. Then, my lord, I have placed the
in your note.
In the judge, my lord, I will just place the citation.
It's not here. It's not here on the note.
I'll place, yes, my lord. I have given those judgments, my lord. So on that ground, my lord, my humble submission is that this right is continuing one, this wrong is continuing one. I am being deprived, my lord, of my right, my lord. And if lordship will have a look on the recent judgment also, my lord, 2025, my lord, 2025, because this honorable court and the honorable Supreme Court continuously has been reiterating this principle of law. That state of West Bengal versus Palm Developer, my lord, that is the recent judgment, my lord, on this proposition of law, my lord. If your lordship will paragraph 2223 of my lord. Paragraph 2223 of Palm Developer. This is a judgment 2025 3 SEC 356, my lord.
Yes. Yes.
Last line of paragraph, paragraph 22. A cause of action is in continuing when the act alleged to be wrongful in repeating over a period of time. Consequently, extending the limitation period, cause of action is a bundle of facts which give rise to a legal right. When in the present case, cause of action is the termination of agreement, the first order and the memo dated 8/3/2016, Lord. If my lord, we have carefully perused the underlying application preferred by respondent before the High Court. Facts sought to be brought on record relate to subsequent debarment orders with their respective challenges. Adjudication in the civil suit will be incomplete and ineffective if the consequent facts are not brought on record. This is due to fact that consequent debarment order related to chain of finding, genesis, memos, and so. Lord, so therefore, your lordship and the Honorable Supreme Court in number of judgments, my lord, have held that if the wrong is continuing one, kindly appreciate in the facts of the case that it is a wrong which is a continuing one, deprivation of my right to life under Article 21 because it includes right to shelter, my lord. Chameli Devi is the authority on that point, my lord. Kindly have the citation of Chameli Devi. The right to this, my lord, citation is, my lord, 1996 to SAC 549. Right to shelter, my lord. And kindly just take note that this honorable court in Chameli Devi, the honorable Supreme Court in Chameli Devi held that right to shelter is fundamental right. So if fundamental right to property under Article 300 capital A are being deprived, is it open to the respondent to say that there is a delay? When there is a delay on their part, they did not hand over the possession of the building despite I succeeded for 15 years. Despite I made the plan way back in 2015. I have come to the court in court, and then court directed them to pass the order in 2019. They have taken 4 years. Then I went to the civil court. I have been running from pillar to the post. Certainly under writ jurisdiction, my lord, your lordship will consider the aspects that it is not as stringent as in civil suit. But even in case of civil suit, your lordship will find that it is per se within period of 3 years.
Let's hear Mr. Manta.
Civil suit was decided in 3 years, my lord. So first ground, my lord, I will just repeat. First ground which I have taken, my lord, is that the order is contrary to the order.
No, we noted submission, Mr. Mr.
Second is
Kumar.
violation of 238,
Yes.
and third is there is no
See, given
delay
is
on my part, my lord.
speaking statutory order
my rights are
necessary,
continuing.
non-speaking order, then yes. Just hear Mr. Manta. Yes. You can finish in 10 minutes.
10 minutes is very difficult, Your Lordship, because the citation they are giving just now to me is supplying. I have to go through that. But whatever the facts my colleague has stated, Your Lordship, in fact, there is no delay on our part. Everything we have done legally, Your Lordship. This is a fresh cause of action. That is, my colleague has missed that part. After disposal,
how do you see fresh cause of
after
action?
disposal of the appellate authority, they directed to give them a fresh plan. This is a fresh cause of action. The earlier cause of action extinct.
So you mean to say that they did not submit fresh plans?
No. After the appellate authority, they submitted. There is a fresh cause of action.
Right, so fresh plan. But
So,
then
when the fresh cause of action
then
accrues,
sat on. See, from
1 minute, Your Lordship. When the fresh cause of action accrued,
that
then
the matter went up to the
that under 235 they give the application with all billing plan, everything given. There is a fresh cause of action as per the appellate order. So once a fresh cause of action has come, then they are attracted under 340. There is a problem because they, instead of going 340, they choose to file the suit, and later on they have withdrawn without liberty. 340 they miss, Your Lordship. Otherwise, this could have gone smoothly. Is the drawback on the part itself, on the petitioner, is none of the follow the Contempt Board. And if I come to the order, Your Lordship, Union of India is a necessary party. Even the appellate authority indicated that. But how they can bypass that? This is another hurdle they have to overcome, Your Lordship. And let me go to the appellate order.
Yes.
Just for a moment, Your Lordship.
One thing before you supply the other copy, the cited decision.
You have to supply.
You kindly supply
citations,
the list
Yes.
to the
we
and also you can you give the printouts of the ones you cited.
My lord, we have already given all the ones we have cited.
And the ones cited here in this.
In the list, we will supply, my lord. We will supply all the judgments. Yes.
Right. Yes, Mr. Manta.
Yes. So, appellate authority, that order, Your Lordship.
Yes.
What's it, please? 246. 246, Your Lordship. The relevant portion, Your Lordship, will come. 256. I'll come to the relevant portion, Your Lordship. The Contonement Board, Your Lordship has got it?
Yes.
The Contonement Board Ceylon Contonement shall process the case for necessary NOC of the DO Guwahati, Defence State Officer Guwahati. There is a Union of India, Guwahati Circle under the Contonement Act 2006. DO Guwahati, this is number 1. DO Guwahati Circle will process the case in accordance with the provision of section 238 subsection 3. 238 subsection 3, for a moment, if Your Lordship allow me to read, and Lordship can see this. This is a mandatory provision, what the appellate authority give me. 238
Yes.
Your Lordship, the Lordship has got that. The board, before sanctioning the erection or re-erection of a building on land which is under the management of the defence state officer, shall refer the application to the defence state officer for ascertaining whether there is any objection on the part of the government to such erection or re-erection, and the defence state officer shall return the application together with his report thereon on the board within 30 days after it has been received by him. So, defence state officer is a necessary party under the Act. Therefore, appellate authority also directed that this provision has to be complied with. So, they cannot escape the Union of India. They are necessary party. And more hurdle comes why they you not say that they rejection, they say it's an order in one line, due to objection from the defence state officer. This plan was rejected. So there ought to be a party. That hurdle has to be overcome. This is number one. Then though they say number 238, section 5, subsection 5, with the board that rejection reasoning, before that let them comply this subsection 3. They have not complied. They should have gone. Then let us come to section 250. If your Lordship please to come to section 250 of the Contempt Act.
The Queen of Fellow suit. That's submission.
Yes, your Lordship. 230. Sorry. 250. Court not to entertain proceeding in certain cases, your Lordship. Subsection 1. After the commencement of this Act, no court shall entertain any suit, application or other proceedings in respect of any order or notice unless an appeal under section 340 is preferred and the same is disposed of by the appellate authority under subsection 3 of the section 343. That alternative this remedy was there. So filing of the suit was also very wrong. This was obtained at 340. Further also this petition doesn't lie. Because there is a fresh cause of action. Under 235 they have...
What about the point of remand?
Point of?
Remand. That they've raised, that the order, the authority...
Yeah, that was disposed of. That was disposed of. So your Lordship will see...
That means it is...
In 2019 it was disposed of.
Specific points to consider, correct?
Yes. You read the last part of this order.
Yes.
So let
now
me
just read this part again.
Yeah.
Contonement board shall process the case for necessary NOC of the DO.
Yes.
That means the board has to set
the process we have done.
Process it before the DO, right?
When they submit the plan, then
under
it
the
was
Act, the DO Gauri Circle process the case in accordance with the provisions of 238(3), and within the time of 1 month should be therein.
Yes.
The DO Gauri Circle shall report to the Contonement board on section 238. Correct.
They have given that 452.
Specifically comment upon the issue requisition, okay, zonal plan, okay, so on and so forth, upon receipt of the report DO. That means the report DO was placed before the Contonement board in the imprint order.
No, after that you also will see.
No, one second, just one query, just to clarify things. Now, after the order was passed by the appellate authority, then the plan was put for the DO.
They have submitted.
And then the DO
then we have submitted DO.
Is examined it and
DO
has sent it back
that
to
is in
Contonement board.
452. Your Lordship will see.
Has sent it back to Contonement board.
Yes, with the objection.
And Contonement board, upon receipt of the report, then the Contonement board will consider permission for erection, re-erection. Now, was these steps completed? Now, after the erection as contained in this...
Completed. That's it will reply at 452. Your Lordship will see.
Just 1 second. It was sent to DO.
Sent to DO, then DO responded this. It is here. Your Lordship.
Report and place it for Contonement board.
Contonement board.
Yes.
Then it was decided on the basis of DO's objection.
Report of DO in the Contonement board resolution.
Yes, that was discussion. It is there.
Where is that?
At page 452, your Lordship.
Because the submission is that it is a non-speaking blind order.
No, it is there.
Yes.
Everything has been followed. 452, your Lordship will see the last paragraph.
Yes.
That resolution, that 2, notice to erect or re-erect building under section 345 of the Contempt Act 206 in bungalow number 33, survey number 32 at the bottom part.
No, 452.
452.
Notice to erect, re-erect
street of that. This is the objection.
Geo Guwahati Circle.
Yes. The Geo Guwahati Circle, white later dated so-and-so 19/8/2019 had returned the building notice dated 1/1/2019 under section 235 of the Contempt Act so-and-so in form A and B along with 2 sets of building plan as forwarded by this office letter number so-and-so 26/2/2019 and as unsanctioned, S is missing there, unsanctioned as per objection of the local military authority raised by para 3D and 3F of the station cell number so-and-so. Due to that, this has been rejected.
I don't understand this. Now you say, okay, just read it slowly.
This, as per this duos, unsanctioned.
That's also on action.
No, unsanctioned, S is missing.
No, it's not. This is not sanction spelling.
As unsanctioned as per objection.
Sanction will be, there should be an N in the middle.
As per objection of the local military authority.
No.
Local military authorities give the objection.
No. It doesn't mean like that, Mr. Manta, I think. The DU
I can produce the original also.
Board has not at all considered, Lord. If you will see the order.
No, 1 second, Mr. Let Mr. Manta submit. You have had your, we will hear your replies.
As the local military authority, they have raised by para
objections. Okay, fine.
They have raised para 3D and 3F.
That's well and good. DO is going to report. Now, whether this was discussed in the Contonement board, that's the only thing. When they were,
that was discussed in the board. Therefore, this is the resolution. It is replied in the resolution. So I can produce the original copy of that resolution. That was not read.
Now, resolution.
As per that, then the next resolution came in 454.
The resolution only says that the matter is very deliberated
by the board. The board took note of the stay order on acquisition of the High Court Data 1988 on the letter 3/10/2019 that the LMA on later dated 27/9/2000 LMA that objection that one. All those were discussed, Your Lordship. They should have gone under 340, not under 226, not under title suit even.
So title suit no liberty order board again is the executive order. It's the executive order of the Contempt board on a fresh building plan, building submission 238.5.3.
My responsible submission is they should have gone under 340 against the rejection. That is the provision of the Contonement Act.
No, but submissions that is.
Then instead of going that, they went for title suit, Your Lordship. Then at last title suit that they cannot get any remedy, so they withdraw without liberty. So it is their own fault, Your Lordship. For the fall of the petitioner, that no court can give any extraordinary relief.
So you mean to say, as per the directions of the authority, everything's been carried out. There's been no latches or lapses or speaking order has been passed. That's your submission.
Yes, sir. By submission, they have passed all the speaking order. There is no wrong. In fact, they should have gone against this order.
So that's for them to. That's for them to.
That is a law.
To whatever take recourse, whatever. They have not done that to the peril.
Till that they have not done, Your Lordship.
Your submission is that this order is well within the bounds of law.
Within that, it is.
I mean, it is a speaking order.
Yes,
everything's been considered. Yes. The records reflect that.
Yes, I can produce the record. I'll produce the record.
Yeah, produce the records.
Yes, I'll produce.
But the whole thing hinges on that. The whole submission is that appellate authority gives directions never considered, and just by a press order, rejected.
We have discussed all those things.
And this bill will not even record will not, because these are all statutory orders.
They are just picking up this part.
Cannot be improved by records also.
No, records will show whether. No, even all the discussion were given to the petitioner the copy. I'll check the record
of the deliberation.
Of the deliberation.
Mr. So and so of
petitioner. It was
member of Contempt board has said this.
What had happened that always Contempt board always submitted.
If I remember correctly, in other proceedings is recorded.
Silent, Milord. Order is completely silent.
You can produce it by Tuesday.
I can ask them to produce the record.
Yes, heard at length. With regard to the impugned order, that is dated
10th October 2019, my lord.
10/10/2019, as there has been an assertion on the part of the petitioners that the matter was not deliberated upon as per the directions of the appellate authority, and
big photos.
terse and order has been passed, TRSE. Mr. S. Vimantana, Senior Counsel, appearing for respondents, praised that he be allowed to produce the records showing the minutes of the proceedings that was held, that culminated in the impugned order, dated
10/10/2019.
19 years. This on Tuesdays.
Even the letter addressed to the Junjunwala, 10/10/2019. This the letter. I got a photocopy.
Can you kindly just flag them, the relevant parts?
Yes, I'll bring the records. Not original.
And a copy may be provided, though my argument is, my lord,
No,
that
copies, the records are not necessary as far as satisfaction of the court.
Order speaks for itself, my lord. Order is very clear. They say
That is your stand. Yes, you can maintain your stand. We will see. Yes.
Yes.
Which way it goes.
Difficult to say. Anyhow,
I don't understand how.
My responsible submission, you will also 226 cannot come into play at this stage without affording 340.
There's not a point here. Anyway, that's different.
There's a legal hurdle. They have to come and to necessary party that union day about it.
We have all technical.
Yes,
that is very important because you cannot avoid
non-joiner of necessary parties.
They have the necessary party. If union you avoid, so you come into play. So it cannot be.
Right.
We'll meet all.
State to state, you cannot.
My lord, the remaining judgments also in the list we have submitted.
I'm grateful, my lord.
Tough case, Mr. Kumar. Yes.
My lord,
Lordship will see my rights are being taken away, my lord. Lordship, and that right is a right which has not been.
Rights when taken, you never exerted your right. You never fought for your right in the correct way. So you can't expect.
I have Lordship's kind.
The right says, okay, fine. You're entitled to go by. See, Mr. Come to this. The order says you're entitled to go by plane. You start taking the train. Who stopped you? Who asked you to do that?
Nobody knows. Even he knows very well that 340 lies.
Simple as that.
You will not find fault with the client for wrong advice.
Yes.
Yes. Always lenient in those matters.
My lord, item 31, I was on the legs at court 1, my lord. It was 31, my lord. It is done. My lord, we have already filed an affidavit in the time for responding.
You can't take the submissions now. Yes. 31. Yes.
37.
Obliged, my lord.
Yes, Mr.
May I please, Lordship, as per the last order 11/12/2025, Lordship, my land senior is supposed to obtain some instruction, Lordship.
No, Lordship will let the matter be heard and merit, your lord.
What's the matter about?
Lordship, that deduction, your lordship.
The?
Deduction of money salary.
From the salary, your lordship, from the money committee. Because there was a judgment passed by.
Oh, that is very. That is where's the hard case. Where's Mr. Islam?
Our Islam is today is not in position, Lordship.
After 3 weeks.
Very hard case. Yes.
Much of
Yes, due to the absence of our counsel, it's about 2 weeks. But that was what?
37 and 38, Lordship.
38, Lordship.
39.
Lordship, fresh steps have been taken upon respondents number
6 and 7.
7 and 8. Yes, 6 and 7.
You are appearing 6 and 7, Mr. Paske?
I am appearing for respondent number 8, Your Lordship.
6 and 7, the process service, they've been served.
Even from the government, we have sent the intimation.
6 and 7 is whom? You
Well,
sent
the managing
intimations.
committees.
They are the headmaster.
Headmasters. Oh, sorry, headmasters.
Yes, Mr. K. Bharashaji also submits that from the side of the state respondents, These response 6 and 7 have been alerted as a penetrated petition. Stop. Mr. Latsang Loya also submits that steps have been taken. In the interest of justice, however, that matter appear 1 week in the order column, 2 weeks order column. Yes.
45.
Yes. With the pass there for number 8. Yes.
My lord, item 45, my lord, pertains to pensionary benefits. My lord, what had happened in these cases is that these persons, my lord, they were initially discharged, my lord, under Rule 26, and due to stay order passed by this court, they continued in service, my lord, till sometime in 2016, 15 March 2016. Now, thereafter, my lord, they have been, my lord, discharged from service. The question now is that, my lord, their pensionary benefits as to how it would be calculated. Because, my lord, knows that from 1st of January 2016, the 7th CPC had come into force. So, as far as, my lord, his pension is concerned, my lord, page 20 of the affidavit of the respondents, it would show that pension has been revised according to the 7-pay benefit, 7-pay commission benefit that he was getting. But then as far as, my lord, gratuity and the commutation is concerned, my lord, the corresponding change has not been made. If your lordship comes to page 20 of the affidavit filed by the respondents, at serial 3, his pension, my lord, with effect from January 2016, that is the pension calculated as per 7 CPC, there was a change. A revision was done, but then the commutation and gratuity payable, my lord, has not been revised, my lord. That is my limited device.
Yes, Dr. Mazika.
Yes. Earlier also given
नहीं है ना?
The short matter.
Yes.
So here what happened, my lord, there are 7 number of petitioners in this case.
Yes.
My lord, in the year 2015, medical assessment was done, my lord, of about 100, more than 100 Assam Rifles personnel, my lord. And on low medical category, they were discharged from service.
Yes.
Now, all of them, they came before this honorable court, my lord, and challenged their discharge on some technical ground, my lord. Now, what happened when those writ petitions were filed, my lord, the interim stay was granted. And on the strength of interim order, they continued to serve for some for 8 months, 10 months, 12 months.
Yes.
Thereafter, my lord, all the writ petitions were dismissed by this honorable court by an order dated 15/3/16, my lord, 15/3/16, passed by Justice Sen, my lord, in single bench. Now, all the 7 petitioners were also petitioners in those cases, my lord. So, what the issue is, the service rendered on the strength of interim order, whether that will extend the service, because during that period, my lord, 6-pay commission came.
7-pay commission.
7-pay commission. So, whether they will be entitled to benefit of that, because the interim order will merge with the final order, my lord. Now, what happened, my lord? Some of the petitioners, they went and filed an appeal. The writ petitioner didn't file an appeal, my lord. Now, the division bench set aside the learned single judge order, remanded back the matter to the single judge, my lord.
Yes.
Then thereafter, the matter was heard by Justice Dingdo, my lord. An order was passed allowing the writ petitions.
This is WC 478.
They've annexed that, my lord.
My lord.
The lordship will find that at page 25 of the writ petition, my lord.
Writ appeal.
But the writ appeal remanded back the matter
And the single bench's order, my lord, this is 31/8/22, page 25.
Yes.
What's it, page 25. But the writ petitions are not party in the second order.
Before this just ding dong.
Just sitting down.
You're not party.
They're not party.
So they're just sitting on the fence.
They've abandoned their rights, my lord. Initially they came. When Justice Sen disposed of. Now when the division bench remanded back the matter, my lord, division bench remanded back matter only vis-a-vis the writ appellate, my lord, not against dog. Now from the chart, your lordship, if I may just point out few things, my lord. Lordship, see there are 7 petitioners and date of retirement was, so even if they served till 15th March 2016, that was the order when Justice Sen passed the order dismissing all the petitions. So they rendered service till 15th of March 2016.
Up to
15th March 2016. But the actual date of retirement was 1/6/15, 1/10/15, 1/9.
Okay.
So 3 or 4 or 5 months, 6 months service they rendered on the strength of the interim order only, my lord.
Yes.
Now what happened, my lord? They came and filed another writ petition before this honorable court. But you will find that page 51.
291 का order है.
Yes.
This is order with Chief Justice, my lord. I'll read from para 2, 2-3 paras I'll read. Several petitions, including the present petitions, have approached this court for a relief, and all the writ petitions were dismissed on 15/3/2016, Justice Sen's order. The present petitioners was concerned in WPC number 1. All other except the present petitioners preferred an appeal, which was allowed, and the writ petitioner was restored to file. On remand, 21 petitioners, excluding the present petitioners, got favorable order. Against the order of dismissal dated 15/3/2016, the present petitioner have not filed any writ appeal, and insofar as it is concerned, it has attained finality. For the same relief, another writ petition has been filed in 21, which is now tried before this court.
So they came in 21.
No, yes, my lord. And this relief they sought, my lord. Kindly see. The main contention of the respondent is once the writ petition was dismissed and has attained finality for the same relief, another writ petition is not maintainable, and the same is hit by res judicata. I find force in the contention of so and so. In the course of argument, both learned counsel presented the court the order of this court dated 5/4/25/24, passed in WPC number 291 of 23, extending the relief to similarly placed persons like the petitioner. Dr. Sonia submitted the relief granted in this will be extended to the present petitioner also. Learned counsel for the petitioner fairly submitted since there appears to be hindrance on account of principle of res judicata. The benefit of the order dated 5/4/24, passed in 291 of 23, and 9/4/24, passed in so and so may be extended to petitioner also, as the respondent agreed to the extent of the benefit of order for present petitioners if otherwise. Well, here the relief that was given to them, my lord, the salary for the period they served in the extended during the interim order, my lord, for 3, 4, or 5 months. Now they are saying, my lord, because they served under the strength of the interim order till 15th of March 2016,
just get the benefit of
their service should be counted as regular service till 15/3/2016, and because pay commission came on 1/1/2016, that should be given to them. In my humble submission, my lord, this honorable court only protected because they rendered service during the interim order, they should be paid salary for that. But that will not entitle them to pension or 6th pay commission or other benefits, my lord. Because the interim order, whatever was there, that must be the final order. And they are seriously hit by res judicata.
The res judicata aspect, my lord, if I may submit, we have already admitted. So we were not onto the benefit that was passed in those judgments, which went in writ appeal and came back, my lord. We were only in this particular petition on the point that once, my lord, my pension is to be computed. Now, what would be the correct procedure of computing the pension? Lordship knows the pensionary benefits is well settled that last 10 months annulment is the basis on which the pensionary benefit is, my lord, calculated. Accordingly, since the respondents have already revised and given my pension on the basis of 7 pay commission, revising my pension from 1st January 2016 and not 2015, my lord. Since that is granted, my lord, the ancillary computation of my lord, the gratuity and accommodation would also follow, my lord. Had it been a case that my pension was not computed under 7 CPC, my lord.
Why did you compute on 7 CPC then?
That's not correct, my lord.
Where, your affidavit?
My lord, in my affidavit,
Serial number 4, yes. My lord, it clearly shows my
page 6 of my affidavit.
Page 20.
Revised pension per month, revised basic pension, so. Page 6, what do you say? Yes. Yes. 6, a chart.
That chart is an abstract of, my lord, what is there in Annexure 1 onwards, which are the pension payment orders. So at serial number 3 of the pension payment order, my lord, my pension is already revised as per 7 CPC. So the other ancillary benefits are all part of the same package, my lord. Had I not been granted 7 CPC, my lord, I would have no claim for a revised gratuity.
Which paragraph?
This is, of course, a new aspect on it. But they have already revised. Because page 6, you also will see they were already paid their PPO, monthly pension, everything were calculated on 2/1/18. So given the table in respect to all the petitioners. Monthly pension, leave encashment, RGS, commutation, GPF, gratuity, everything is paid to them.
No, only one ground, only one thing was a perplexing thing. Look, they said they have asked to consider the retirement from 15/3/2016, correct?
We have taken that from 15/3.
You've taken that from?
They are asking to take the retirement date as 15/3.
You've allowed that also.
But actually they retired before that.
Retired before that, yes. But then you paid the pay allowances as they were worked till 15/3, the date of the final order, correct? Yes. Now, his case is that after 7 CPC came into effect, you've granted them the revised pension, but without the accompanying revised gratuity.
No, no revised pension is granted.
Then?
Kindly see, my lord.
No, my lord, Annexure 1 says otherwise, my lord.
Okay,
Annexure 1, page 20, last drawn pay as per 7 CPC, 41,100. And revised pension calculated with effect from 1st January 2016, rupees 20,550. So they have revised me according to 7 CPC. But then the ancillary benefits, no change, my lord. At serial number 4 and 5, corresponding changes have not been made.
Just check it, Dr. Muska, we'll have it after 1 week.
My lord.
At least after 1 week before the hearing. Just if it's been given 7 CPC, then you can't give one part with whole other part. You should have given on 7 CPC. If you say only notional thing, notionally you've given their pay allowances 15/3, well and good. But that's the only thing. It only stands to reason.
Some mistake in the affidavit, Simpson.
Some mistake in the affidavit?
Yes. Because.
And how are you going to correct that?
Page 6 also says that 20,550, revised also is 20,550.
No, this up to 1 week, yes.
After 1 week.
46?
My lord. Oblige, my lord.
Yes. The same, PGD complex.
Which one?
46.
Yes, please, Your Lordship. Your Lordship, I'm praying for time in this matter, Your Lordship. Your Lordship, we yet to receive instruction from the university.
You're not interested anymore.
Lordship, what happened, Your Lordship? There was a meeting convened by the Honourable Minister, Your Lordship. It was decided, Your Lordship, that the state would resume the property, Your Lordship. That was a decision taken, and accordingly, that has been informed to, a letter was written to the Vice Chancellor of Nehu, Your Lordship. We are yet to, he's yet to convene.
But Vice Chancellor, where's the Vice Chancellor?
Because that was the decision, Your Lordship, taken in the meeting.
Yes.
Let's come after 3 weeks, then, Your Lordship.
Yes, let
Lordship,
I request the parliament to 3 weeks, yes.
Outline.
Interim orders and to continue, yes.
7.
Yes, Mr. S. Deb. Start.
May it please, Your
Yes,
Lordship.
matter about?
Service matter, Your Lordship.
No, no, where's Mr. S. Deb? Have you previewed the records? What do you have to say? They've seen, they have made.
Yes, madam.
Yes? He made notes on the records.
Lordship, I pray a short accommodation, Your Lordship.
You have MS, what's your name?
M. Nayang.
Where's Mr. Deb?
He has some personal difficulties.
Both of them have gone home, Mr. D and Mr. Deb. Yes. After one week.
48.
At the request of MS
MS Nayang, Your Lordship.
Nair.
Nayang.
Naya.
Nayang.
Nayng. Which part of this you from Jente Hills?
Yes, Lordship.
Okay. West or east?
West.
Never heard of this title, yes, first time.
48.
MS Nayang, okay. Where's Mr. Sheikh?
May it please, Lordship. Lordship, in this matter, we've just been newly appointed, Your Lordship. I'm for respondent 4 and 5.
And you for 6?
Yes, Your Lordship, kindly allow me to file additional document.
No, that hearing stage, no.
Yes, Your Lordship, this additional, my appointment was on undertaking, on the basis of undertaking. However, I have complied with the undertaking. So kindly allow me to file those additional documents to bring on record.
No objection.
I have objection, Lordship, because they have already affidavit in opposition, Lordship.
But Your Lordship, this this undertaking was complied by me, Your Lordship.
5 and 6 is whom?
Archival.
No, 5 and 6. You're for 5 and 6. Or you're for 4 and 5.
4 and 5.
4 and 5 is a school management committee.
Yes, Lordship.
Yes, MS so that the parents has submitted that they have just been engaged on behalf of 1, 4 and 5.
Lordship will be filing power in the course of the day.
And says that and submits that the power will file course of the day. You Mr. Rabil, your Hibul Haq.
Tajirul Islam.
Tajirul Islam. Then it comes to number 6. However, has made a prayer that the may be allowed to file a short additional affidavit on verse number 6. Bring on record the fact that
Your Lordship, I have complied with the undertaking as my appointment was on the basis of undertaking.
That he has complied, that the petitioner, that the respondent 6 has complied with undertaking. As what was your submission just now?
Your Lordship, my submission is that I have complied with the undertaking during the pendency of the case because my appointment was on the basis of undertaking.
Yes, that he is compliant during the pendency of the case. Stop. The same objected to Mr. M. Ramarak. Right?
Yes, Lordship.
Yes. However, in interest of justice, the additional affidavit is allowed to be filed, and objections can be filed by the petitioner if deemed necessary. Just after 2 weeks, yes, in the order column. Yes.